to do?
Your Lordship, within 1 month, already 1 month is completed, Your Lordship. And respondent number 5 to direct.
They will at the best initiate contempt. You wait. Oh, there is nothing not that urgent.
Lordship, respondent number 5, we are not reinstate the police complaint also, right?
18th, sir. 18th of this.
Please.
Any mention through VC, sir? Sir. Contempt matters, number 1 to Bhargav N.
Appearing for
There
the
is an
Notice,
order passed by the court.
notice returnable.
No, my lord, they have filed their objections.
They have filed their objection.
Yes, my lord.
filed
What has,
affidavit, my lord.
what has happened is,
Page.
there is a direction issued by your lordship's court, my lord.
Dated 16/11/23.
Please come to my lord, page 29, 30. This honorable court directed that, my lord, they must pass orders in terms of the decree passed by the civil court.
Not
They, my lord, contended that, my lord, in a criminal case, my lord, all the documents have been seized. They have to restore my name in the revenue records. They said, my lord,
Where is your reply?
My
Compliance.
reply, my lord, is dated 16/11/23, wherein the relevant portion of the affidavit, my lord, is para 4.
they say, my lord, originals have been seized. Same contention was raised before the single judge. Same contention was raised before the division bench. Division bench said, my lord, comply with it within 3 months.
My lord, para 4, 5, and 7 may be looked into.
This is no ground not to comply.
That's all I've said.
Para 7, my lord, para 7 for a moment,
There are 7.
para 7 also. We have preferred.
Even this is no ground.
That's what I say. You'll have to take the original, seek the instructions of the court, take it, rectify it.
My lord, just for a moment,
Are you taking remedial action or shall we pass the order?
no, just for a moment, if your lordship can kindly.
These are not
see
down
which-
not to comply. We are not concerned with any merit, any development. We won't comply. That's all.
Let me take a week's time, my lord.
While allowing the petition in part, learned single judge directed the respondent to Tehsildar, Dodalla Ballapur, to take action in accordance with law in implementing order dated 24/4/12. Keeping in view the decree passed by the civil court in original suit number 246 of 2002, dated 13/3/2008, full stop. When the contempt proceedings were filed in respect of non-compliance of the above directions, upon issuance of notice, the respondent Tehsildar appeared and filed affidavit in which it is given out that in the other criminal cases, the officers have seized the documents. It is the second ground urged that the criminal appeals are pending in respect of subject matter. The court is afraid that the above, either of the two could be a good ground not to comply with the directions of.
I'll
the
take notice also.
So respondent shall take remedial measures on the next day and demonstrate before the court, failing which
Please.
the court will be compelled to take a serious view of non-compliance.
Is there a date, my lord?
You just advise this is not the ground not to.
Please, I understand. Is
Whatever
there
you do, you get the papers back and then get the copy of the decree. But
Is there a date?
Please,
when shall we keep? January?
January.
first or second week, my lord.
Second week?
Please, my lord.
Please.
As your lordship, please.
16th January.
Please.
Much obliged.
Still number 2. The Lata Sri PL.
My lords, the
Notice.
petition, my lord, notice is ordered and they filed certain.
Notice already issued.
Please, my lords.
Where is the notice is not issued? Notice is issued.
The notice is ordered, they have filed an affidavit, my lord.
These are all not fresh. man.
Notice only, yeah.
Yes, what is the compliance review?
Lords, the petitioner's fathers expired due to electrification, my lords. And there was a direction by the single judge
to consider the representation for compensation for Electricity Act. Who, yes,
This is the BESCOM, my lord. BESCOM needs to comply with it.
shall we keep it back? Next week, my lord, next week, then it will go after. Immediately on reopen, 8th of January. Great. 8th of January, awaiting the presence of learned respondent in bench. Next.
This number 3, Mr. Manjunath BS.
Lots, in this
This
matter,
is a
my
matter of
lords,
ex-servicemen.
Lots, may I- before she makes a submission, my lords, additional advocate general is appearing in this matter. Some difficulty, my lords, it may be taken up next week, my lords. Monday also it's. fine.
My lord, they have filed an affidavit just yesterday, my lord.
Yes,
In that, I would like to just mention a
Lord,
certain things, my lord.
my lords,
It's
additional advocate
contradictory
general
to
is
the previous
interested with the
affidavits, my
matter,
lord.
my lords.
Kindly see their affidavits, my lord.
Lords, I have instructions that additional advocate general will be appearing in the matter.
Everybody is welcome, but you are fighting like anything.
Lords,
Poor
and
soldier
he has argued also, my lords. It may be
Poor-
taken up Monday, my lords.
The ex-serviceman wants a land. He was prior in point of time in making
Lords,
it.
Lords, Monday, my lords,
When shall we?
Monday, my lords.
Monday.
You're obliged.
Monday. Number 4, Mr. Iremat Jagdish.
Here we have complied, so we have filed our compliance affidavit also.
Number 4,
Decided.
Lots.
Representation is decided.
Please, my lords.
Where is the petitioner? Shall we keep it back?
this is number 5. Abhimanyu Arjun.
Lords, in this matter also, we have substantially complied, my lords.
What does it mean? This is
Lords,
deciding.
all the complainants except complainant number 7 has been observed. Monetary benefits have been granted to them. Pension also, my lords, one of the complainant is getting because he's already
Only
retired.
for
Lords, if I may submit,
Lords,
Lords, I have not been
1 second consideration of the
Hmm?
representation on mention of the.
five. This is serial number 5.
Page-
We have
page-
considered, my lords, considered, we have considered.
I have not received the copy of the compliance affidavit, my lord.
You copy. Pass it over.
Lords, I am maybe allowed a week's.
No, you read it, it is just a deciding representation. What more it is? Very. There's not any- Yeah, without notice, that is good.
And the endorsement is challenged before the writ petition also, my lords. They've challenged it in the writ petition. It's mentioned in our compliance affidavit in paragraph 6.
Paragraph 6.
Please, my lords, so page 3 of the compliance affidavit.
So in your paragraph 5, nothing remains.
Please, my lords.
The direction of
Post
the
office
single
petition.
judge in order dated 3rd April 24 was to decide to consider the representation filed by the petitioner in response to the notice from a compliance affidavit is filed, in which it is inter alia stated that the Department of Personnel and Administrative Reforms Integrated Services, after considering the representation, form issued endorsement dated 2/7/24. Copy of the said endorsement is produced. It marks a decision on the representation as directed by learn a single judge. In the above, nothing survives in the present proceedings. The contempt petition is disposed of as not surviving. Paragraph, it is clarified that if the petitioner has any grievance, the merits of the endorsement, it will be open for the petitioner to institute appropriate independent proceedings in accordance with law. In accordance with law, in respect of it, this court does not express anything on merits.
Issue number 6.
That's in this matter also, we have substantially complied, my lords.
Page 76.
Yes, my lords. Page 76. Now, my lords, out of 7, my lords, 6 are given all the benefit, my lords. Out with respect to 1, there's a review petition. I'm not pressing for that, my lords. But what has not been complied, my lords, is the consequential benefits that the court ordered to. And my lords, with respect to the quantum of sum that was given to me, I have a dispute with respect to that, my lords.
That's
But-
all.
Yes, my
That's
lords.
all.
That I'll go before the tribunal and urge my remedies, my lords.
Good. In-
Lords, we have substantially complied, my lords. These are the details. Lords, all
Learned
the,
advocate for the petition, Mr. So-and-so, as well as learned additional government advocate, Srimati Demarcation. They said that the order brought under the contempt jurisdiction is complied with. A statement showing the details of the compliance, giving financial benefits to the petitioners is produced, which is taken record. Paragraph, learned advocate for the petitioners, however, submit that he has some grievance about the calculation of the amount paid. Full stop. In this regard, it will be open for the petitioner to approach the appropriate forum, including the respondents.
Yes, my lords.
With his own calculation and sort out the differences. However, the contempt proceedings are closed and disposed of as not surviving.
I'm ready, my lords.
obliged.
Number 7.
Here, we have complied and filed.
Complied with. Very
Lords,
good.
we have filed the compliance affidavit.
So today is the day of compliance. Madam,
Lords,
today is the day of compliance.
my lords, I'll take some time in this matter.
Take time.
I'll pray for some time.
What is the direction? Some entries to be restored. Simple.
I'll pray for some time. my
This
lords.
side or other side?
Please, 3 weeks' time, my lords.
It's January 20 as requested by learned additional government. Within which time it is expected that the order will be complied.
Number 8. Timothy Belle.
May I please appear for the complainants counsel.
What is it?
The complainants are traders in beef. And for the last 5 years, their license to sell beef has not been renewed by the respondent municipality.
License to?
Sorry,
License to what?
sell beef.
Oh.
Now, the principal ground on which my applications were rejected was on the ground there is no abattoir in Shimoga.
Why you are not complying with?
They have given an undertaking that they will give the license. When the judgment was about to be dictated,
So notice we have to go, notice is not,
not yet,
notice written in
notice has to.
22nd January.
Please,
Aren't going right?
For the complainant. Not the
This
respondent.
also notice will have to go.
Yes,
What is the age of the son?
he's 7 years old, 7.5 years old,
7.5 years.
7.5.
So
No, may I
today,
make one
today,
submission?
today the son is with mother
He's with the mother in Gwalior.
in Gwalior.
Yes,
Gwalior.
yes. No, may I make one submission. On the last week, the mother had filed a transfer petition before the Honorable Supreme Court, and the transfer petitions came to be allowed. The Honorable Supreme Court clarified that the transfer will not have. The Honorable Supreme Court clarified that the transfer will not have any bearing on the consent order. My lord. She's supposed to come to Bangalore, my lord, for during the Christmas vacation on 22nd of December for 4 days, in terms of the order of the Honorable Court. Therefore, a date prior to that,
18.
18th.
Number 10.
Appear for complaints in this case, Your Lordship.
Yes.
Well, the
So
complaints
it
are
is-
working as a teachers in
What
Moraj
is the-
residential schools, Your Lordship.
What is the breach? You are not continued in service?
I have continued, my lord, but in spite of order of this honorable court not to relieve the applicant's petition, complaints from the service, my lord, they have proceeded to relieve the complaints, Your Lordship.
So today you are in service or not?
No, my lord, I have been relieved, my lord.
Notice returnable on
Specific,
8th January.
please, my lord.
This is number 11.
Yes,
Mr. Nagaraj B.
petitioner is in the alert of the site. Is ready to deposit the interest at the belated. They are not ready to issue notice and execute the sale deed.
So you are supposed to issue notice for.
They have to issue notice to me to deposit the
if the search-
interest on belated state.
Oh,
The petitioner is ready to deposit the interest on belated state, but they are not.
There's no contempt in this.
So you are this one or two.
Two, the respondent number two. They have to receive the interest on belated stage and execute the sale deed.
You have already issued notice.
I have issued notice.
Notice returnable on 23rd January.
21st. This is number 12. The Markesh GS party in person. Seal number 12. Seal number 13. This is a PL matter. Uncle Kote.
I appear for petitioner, my lord. In this matter, my lord, the respondent number 1 to 4 are the education department and respondent number 5 is the educational society and 6 is the college which is run by the respondent number 5, my lord. In this matter, I have sought for an mandamus directing the respondent number 1 to 4 implement the rule.
Notice item.
Yes,
23rd January. You see that this is entirely in your domain as such, but still we are issuing notice.
Please.
Seal number 14.
Appearing for the
To Venkatesh Somareddy, it's a green
Petitioner,
field
sir.
matter.
council, my lords.
My lord, petitioner is a registered society comprising of only the traditional quarry workers. And they belong to scheduled caste and they are from the economically lowest strata of society, my lords. They have been working as traditional quarry workers since time immemorial from the ancestors, my lords, in respect to the scheduled property. My lord, the respondent number 4, my lords, has forwarded their claim for reserving this land for the traditional quarry workers to the concerned forest
Be
department.
satisfied by getting your representation decided. That is also your prayer.
Please, my lords, but may I submit one thing in the meanwhile, my lords,
Okay.
the other persons, my lords, they have applied for the same land and this honorable court issued a mandamus to consider their applications, NSR K.
So they will consider the
And
representation.
my lord, their applications are on 31 ZC. Our application is section, please, my lords.
They will consider your representation, 9, 10, 24.
Please, my lords, may I only submit before that, what they want to do is because there is already an order to consider, my lord, 27th May of others. They want to grant to others. Let that not be granted to anybody till our claim is considered because,
Okay, within 6 weeks.
please, till then, my lords, 6 weeks. Please.
This has to be considered.
Because, my lords,
What is page 56?
56, my lords had directed to consider their applications, my lords.
Same.
Land is same, but application 31 ZC. Our application section 3F, my lord, traditional workers, my lords, there is a statutory, my lord, compulsion for the state government to identify under section 3F, my lords, for the traditional workers. Unless the land is identified, my lords, and notified by them, if they directly consider that application and proceed further, my lords,
So all may be considered simultaneously.
no, simultaneously, my submission is, my lords, 31ZC, my information is, my lord, by virtue of my lord's order, they have proceeded to consider. Our application is kept pending, not considered. 3F has to be considered first.
Not like to interject our own order.
That has to be considered, my lords. But our application has also to be considered.
So simultaneously, within 6 weeks.
Please, my lord, that's true, my lords.
Simultaneously, it means that
That's true. But my lords,
My
well,
lord, their applications have been earlier, that is on 23rd March 2020.
whatever it is.
My lord, in case if it is granted, my lord.
that's the point. They say that's all.
If it is
Then
considered,
find out by Monday.
yes, yes.
Let him find out whether page 56 is acted upon or not.
They are considering that application. That's all. They are also considering that.
Madam,
They are also considering.
My lord, I'll
They are also, that applications are also considered.
have this on Tuesday, my lord. Tuesday, my lord.
Tuesday.
Yes.
No, my lords.
But don't decide in the meantime.
My lord, I'll
That's
just find
exactly our
out,
prayer,
my
my
lord,
lord.
whether it has been decided or not.
Not decided till now.
Order
No.
June 2024.
Don't overreach. That's all.
My lord, no, I will
Take
praise
you-
the correct facts before my lords.
Take instructions, but don't overreach it.
No, 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 my
Your
lord.
lords may kindly direct them, my lords.
Tuesday.
Please kindly direct them not to. Till then, my lord, they will now antedate. Now, till now is not considered.
We have said in so many words, what more?
Yeah.
Not the correct facts I'll place before my lord. I don't want to overreach my lord's orders. The correct facts I'll place and I'll leave it to my lord.
As on today, status may be continued. As on today, my lord, because we are the poorest persons. We are traditional workers. Manually, we do it.
Tuesday, everything next Tuesday.
Oblige, my lord.
Please, my lords. Your lords, oral orders, my lords, that not to proceed, because my apprehension is, my apprehension is now that your lordship has said, my lord, they will predate it and give. I'm informed that it is expedited.
What is
Process is expedited. Is the truth.
lords? What has happened till, my lord, 10:30 today? I'll place it before my lords.
Let it
I
not be,
want to be-
let it be positively, my lords, because the situation is this. We are the poorest scheduled caste
They
persons.
put Application
decide right now.
subsequently.
We'll relegate you to the authorities as per your predecessor.
Third, my lord.
On the contrary, we are trying to find out a balance solution. So that your interest is also preserved and all applications are decided to get simultaneously.
Your lords may kindly pass it.
Let us wait till Tuesday.
As my lord, this. So that the subject matter remains till Tuesday.
We have
Subject
said-
matter.
Said in so many terms.
I'm very sure it will remain, my lord, before this on report. Remain. It will not render infructuous.
No remedy for apprehension.
Because these are the manual workers who, with the chisels they work, my lords. They don't have any power except the power of the chisel, the poorest, my lords, chisel workers. And against the multi.
Then they should have been diligent, my lord.
What we'll do on Tuesday?
Seal number 15,
Correct.
Tesva Shivali.
This matter pertaining to 95(9), the deemed conversion. This is matter pertaining to deemed conversion under section 95(9) of Karnataka. Land
Covered by that order.
Similar matter is produced the order copy at annexure F, page number 33.
That is right. Next slide. So
Yes, my
Then-
lord.
disposed of.
Oblige.
Watch.
Seal number 16, to Mohammed Tahir.
My lord, complete. I beg your lord's permission, my lord. Since I was unwell, my lord, I could not give instruction to the senior counsel.
You are unwell.
Please.
Yes.
This the matter, my lord, in effect, it was heard. They wanted, learned advocate general wanted some more time. That's Mysore DC Bank election.
Your Lordship may have it
That
next week,
election.
Monday or Tuesday. my
Monday
lord.
will, he says not well.
Please,
Well, at item number 47 is also involving similar questions. Therefore, upon noticing similarity,
Similar list
directed
may
to
be
this
ordered
along
along
with this. That
Tuesday.
may also be taken up on Tuesday, my lord.
In the second half, 2:30.
Monday.
2:30. So
Yes.
that it can be put an end.
please.
47 also, man.
Please,
47 also.
47.
10th, can I, 11th, can I request, my lord?
11.
11th.
11.
Please.
11.
Great.
Sorry.
Okay, 47 also.
This is number 17.
In
Say,
this case,
first
my
writ
lord,
appeal.
contempt and writ appeal is connected. Last date of hearing, your lordship, my lord, has directed to connect this matter. And my lord, that they have undertaken before the learned single judge, that they will pass award under 2013 Act. And now they have filed writ appeal before this court.
My lord, appearing for respondent, my lord. Senior is not unwell, my lord. So 1 week may be adjournment.
Everybody is unwell too.
He is suffering from throat infection and viral fever.
The ground is that. we can't-
Date may be fixed, my lord, because they are pleading that advocate is not feeling well.
When shall we keep?
My lord,
When shall we keep?
1 week may be.
1 week?
Ah.
In fact, you have to follow the same awards. Anything is pending before the Supreme Court?
No, insofar as this is the, your lordship, this bench, division bench also clarified. And my lord, this is a 2021 acquisition. And my lord, all of them, they have got under 2013 Act. Because since we have approached a learned single judge by filing writ petition, they have, my lord, said, my lord, it is not applicable. And they have undertaken before this court, kindly see the order, which they have clearly, my lord, stated in the impugned order itself.
Paragraph 2. Paragraph 2.
Paragraph 2.
So when shall we keep? Tell your.
Next, 11th, my lord.
This 11,
11th or 12th, my lord. Yeah,
12.
yes.
Please. But
Oblige, my lord.
This is number 18. Just Sharath Kumar.
And tribunal granted us, my lord, occupancy rights in respect of 4 lands. Respondents, my lord, are claiming, my lord, only, my lord, in respect of 1 particular land. Entire order is set aside, my lord, at their behest. That can't be done, my lord. If my lords look at, my lord, the order passed by the land tribunal.
Only remanded.
My lord, remand is correct, my lord, but what happens is, please look at it, my lord. My lord, what happens is, under the Land Reforms Act, tenants are entitled, my lord, occupancy rights. I was conferred occupancy rights in respect of 4 lands. In respect of, my lord, 1 of the land, they claim, my lord, that they have purchased. So, my lord, the learned single judge could have set aside the order insofar and remanded the matter insofar as that 1 particular land is concerned, not, my lord, the entire order. He sets aside the entire order and demands it. That's all that we are agreed by, my lord. As far as their portion is concerned, it relates to, my lord, a particular, my lord, survey number.
This relates to survey number 13 only.
Yes, my lord.
So in respect of that only remand is.
Very well, my lord. That, my lord, the learned single judge has remanded the whole of it, set aside the whole order.
So Allah, that is the very subject matter of the.
Yes, my lord.
Survey number 13.
Lord.
There is no other survey number in.
No, my lord. There are 4, my lord. 13, 44/5, 7/4, and 7/2, my lord.
So where from we get it from
My
petition?
lord, please come to, my lord, the order passed by the land tribunal, my lord.
Page?
Every page.
Because the learned single judge proceeds only on the, in respect.
193, my lord.
Only in respect of survey number 13, head measuring 1 acre 20. Page?
193, my lord.
19. Yes.
Survey number there and
So it says that 13.
Yes.
Has survey number 45.
Correct, correct.
some survey
That's all.
7 oblique, so
Yes.
13 is 1. 45, 44/5/2, 7/2/3, and 7/4.
4.
But then, this, in the petition, it is only, say, 13.
My lord, he sets aside the whole of the order.
Whole
That
of-
can't. Yes, my lord. Please come to, my lord, the order. Application form number 7 is allowed, grant of occupancy rights in respect of so and so. This is, my lord, the order passed by the land tribunal. Learned single judge's order, my lord, sets aside the whole of the order. That's all I'm agreed by. Please come to, my lord, page 54. Sorry.
Yes, madam.
My lords, the
question before the learned single judge was whether the earlier orders passed in WP, your lordship may kindly come to 47 page number and 48. There were two orders passed by the single judge and confirmed by the division bench of this honorable court, wherein a specific finding was given as to what needs to be done by the land tribunal. The very question was whether there was an application filed under Form 7 was not or not was the question before the tribunal. And they had clearly said what needs to be done. Pursuant to that, what was done by the land tribunal was found incorrect, and that's why we challenged before this honorable court. The very question is, it goes to the root of the matter as to the very form number 7 being there or not. That's where, my lords, we will, this matter may kindly be heard, my lords, next week itself.
Does the issue involve all the lands?
Very true, my lords. Form 7, that's what their case is. Their case is that, my lords. That's where this matter requires, my lords. I'm ready to argue on any date. A very short date may be fixed because it's a remand order. We are also in a hurry. Any date the matter can be heard and disposed
I'm also
of.
ready.
Absolutely no issue. We can, this matter can be heard and disposed of. We wanted to file an objection to their application for stay also. There is a clear finding given by the learned single judge and confirmed by the coordinate bench of this honorable court in WA 1682 of 2008. That's what was not being followed by the tribunal.
After, my lord, looking into all that, my lord, the tribunal has passed the order. It is, my lord, their whole contention is, I am the owner of, my lord, 3-4 sites in survey number 13/1. And that's their case. So it can be only, my lord, remand, my lord, set aside as far as 13/1 is concerned. I understand. It can't be for the whole of it.
6 times the authorities have given us an endorsement. There is no application in Form 7 at all.
That, my lord, your lordships, my lord, set aside that order when they gave that endorsement.
48 may kindly be seen, my lords.
Hmm?
Page 48.
Akil,
The matter can be heard and disposed of, my lords. Any short date we are agreeable, my lords.
In your pleadings, the only reference is to survey number 13.
Yes, ma'am.
My lords,
In the writ petition.
my lords, what has happened here is, my lords, they have gone through and then the entire,
Is
genesis.
correct or not? Petition pertain to survey number 13 or not? Is it correct or not? Actually. Go
With
to-
regard to our, this one, my lords, there is a consolidated,
That question is very specific. Answer is also we want specific.
very true, my lords.
The writ petition was confined to survey number 13 or not?
My lords, the land was converted. I have to get it ascertained, my lords, whether that becomes part of that or not.
Writ
My lords,
petition.
one more submission here, my lords. If there was no forum number 7 at all, then what happens is this, if we are carving out something out of the whole thing, my lords, then what happens is my worry, my lords. That's where I do not want to commit at this moment, my lords. It may be kindly heard, my lords. Because what happens is the origin of our case is on the basis that there is no form number 7 at all. If I say with regard to form, this particular survey number or with regard to other survey numbers, there's a different question altogether. That's where I do not want to, I request this honorable court to kindly hear the matter, my lords.
Posting the order dated 24/15. Where is that order?
Please, my lord.
Rare in the writ petition. 203.
Yes.
What is that order?
That order, my lord, was, the lordships, my lord, directed that form number 7 be, because my form number 7, my lord, kept, in cold storage. So they said, resurrect it and then, my lord, give my, this thing.
They have entered into an agreement of sale, my lord, subsequent to this. 17. With regard to 13/1, they have entered into a sale agreement.
Therefore, my lord, it has to be only confined to 13/1. It can't be something else.
A day's time may kindly be given, my lords.
Pardon?
A day's time may kindly be given, my lords. It may be taken on Monday or Wednesday. We'll get back.
There is no urgency then after.
Please, my lord.
After 23rd January as requested by.
Only thing is, my lord, let the land tribunal, let it not, my lord, proceed further. That's all.
Land tribunal for Madbharati first. Till then.
Will not record, but we'll seek your assurance.
Land tribunal ಅಲ್ಲಿ you should not go ahead. Inform them. They don't do it also. It doesn't
No,
go
no.
in that fast.
That, my lord, they have come here, there's an order. I don't want that, my lord.
In fact, the application for stay has been served. We wanted to file an objection. Third, nothing will happen, my lords. Before third, I don't think that anything is going.
23rd is what my lords have said.
23rd.
Huh? Third is.
Sir,
what
you
we're
don't
talking.
think, you say that nothing will happen.
23rd is of this month, my lord.
Next month.
Grateful.
So we take it that nothing will happen. Otherwise, all
Yes, I will ask them to.
That's
23rd Jan, as requested.
This is number 19.
Anything happens, I'll move your lordship.
Pardon?
If they try to, my lord,
Ah,
I'll move your lordship.
yes.
Number 19, MC Basurai.
But the appellant is a person of disability. And the medical board, my lord, has issued a disability certificate certifying that my lord is suffering 40% disability. Considering the opinion given by the medical board, my lord, he was accommodated light wall. And instead of protecting the space scale, my lord, my lord, as per clause, my lord, as per subsection 1 of clause, section 20 of the persons of disability, my lord, the pay protection is mandatory, my lord. My lord, instead of protecting the space scale, my lord, they have changed the cadre itself and subsequently issued an endorsement. Lordship, kindly see subsection 1 of section 20 of right of persons with disabilities. It is very clear, my lord, they have to protect the pay scale.
What was the disability?
My lord, he is suffering annexure. B is the certificate issued by the medical board, my lord.
What was the disability?
Yes, my lord, right, is restriction of movement of right knee.
Right knee. But then you are coming after 13 years.
My lord, they have accommodated light work in the year 2010. Then, my lord, instead of protecting his pay scale, my lord, they are continuously paying the pay scale attached to the post of attender instead of driver. My lord,
What you
pay
stated
protection is mandatory, my lord, as
in your
per
petition,
section.
what is stated about the passage of time to
My
the
lord.
extent of 13 years before you raise your grievance?
My lord, subsequently, my lord, they have issued an endorsement.
No, what
Before
you
that, my lord, he has approached.
how you explained the passage of 13 years in your petition? Any averment is there?
Yes, I will. Para 9 of the appeal, my lord.
When did you retire?
My lord, subsequently, my lord, 2024. 2024.
24. So after filing the petition,
Yes.
difficult, but if anything can be done. Notice in meritless matter. Returnable on 24th January. The 28th January. 28th January.
Still number 20, Shatabish Suvarna.
Take please, your lordship. But I am in 20.1 and 20.2, which I respectfully suggest first take up. Because Lord, I don't want to get caught in this fight. I am a poor man who has been dragged into it, and Lord, the learned single judge has damned me. And I am likely to be arrested at the age of 80 years for something that happened 24 years ago. So Lord, I have a slightly different issue. I am not on this.
Whichever appeal is substantive, in your view, will take up first.
Sorry?
Whichever appeal is substantive.
Lord, mine is.
Your perception will take up first.
Lord, mine is a very substantive issue because I was not a party.
By serial number.
Yes, I was not a party. And unfortunately, my Lord, what has happened is in my absence, the learned judge has not condemned me beyond imagination. That's why I am before your lordships. So, my Lord, I am ultimately now, my Lord, facing a prosecution. Learned judge has commented upon the merits of the prosecution and has left no remedy now available for me. So,
My Lord,
I would like to show
in this
that.
matter, my lord, in 20.1 and 20.2, I appear, my lord, for respondent number 4 and respondent number 1 respectively. Your lordship may kindly see 20.2, my lord. All the only order that has been passed by the single judge in
Mr. It's my petition. Why do you want to interrupt just now?
is to
Mr.
simply
Raghavan, it's my petition. Please allow me. Do you have any preliminary objection or what?
yes, with respect to 20.2, yes.
Correct. By suppressing vital documents, these orders have been taken. I will show to your lordships.
Appeal will consider.
Sorry?
You are seeking leave to appeal.
Yes, my lord.
So we'll consider.
Yes, my lord.
Let the first main subject matter be addressed.
Lord,
your lordship may take up his matter first, brothers. Your lordship may take up his matter first. I'm in the first matter. Let that be done first. No problem.
Lord, I'm grateful to Mr. Singhvi. Lord, just turn to page, Lord, 88.
Which one?
Take up, Lord, 1713 of 2024. 20.1.
But all will travel together. We may take up first, no difficulty.
Yes.
But all three appeals will travel together. That
Yes,
is
of
what-
course. But Lord, I stand slightly on a different footing because I was not a party and I have suffered. Lord, one principle that has been settled.
We understand, but even then, all matters will travel together.
Of course, Lord, they will
As far
travel
as the procedure and
But
decision.
today I am more anxious than them because I am facing, Lord, this condemnation in my absentia.
All are appearing in your matter. All respondents are appearing.
Lord, they were,
Notice.
your lordships.
Notice may have
Last
to
time,
go.
Lord,
Notice may have
last
to
time
go.
they appeared, Mr. Maninder Singh, Mr. Raghavan, learned Solicitor General, they were all there. I don't know which matter they appeared.
Notice is not at issue. Notice may have to go.
Yours,
Complainants are on caveat, my lord.
yours is 1713.
Yes, my lord. And 1719. Both.
But right now, leave to appeal is 1713.
Yes.
So who are the respondents? All are appearing? Then
Lord, they are on caveat. Yeah.
Number 3 appearing.
Page 6, my lord, they are on caveat.
There are
The
six-
complainants.
20.1, my lord, respondent number 4.
3, 4, 5 are on caveat.
Notice may have to go to respondent number 2, my lords.
Appearing for the state in this matter. I'm appearing for the state.
Appearing for the state.
State,
Number 1.
please.
But the notice will have to go number 2 and 5. 2 and
Mr.
6.
Tushar Smith had appeared before the learned single judge. Notice may have to go. my lord. Only after that, probably.
Lord, I am really not concerned about 17A order by the Excellency, the Governor. That's between them.
My lord is saying all must travel together. That's in that context, my lord. the
Only
Chief
thing that
Justice.
you may be separate.
Yes.
But at least in hearing part, we can't disconnect the things. That is what we are suggesting.
Lord, I would respectfully urge.
We'll treat you separate.
Yes, Lord.
You are separate.
Because, my Lord, I am getting dragged at the age of 80 in this, my Lord,
there is a-
slugfest.
There is a.
I have nothing to do with politics.
You remain Jal Kamalvat.
I asked my client whether he voted for BJP or Congress. He said, neither. I voted for Janata Dal. So, my Lord, why should I suffer because of all
So
this?
lotus
But
in
you have to
That's the
suffer.
reason.
You have to suffer because you are the Janta.
So, my Lord,
lotus in a water doesn't have the touch of water.
yeah, that's
So
true.
we'll keep you like that.
Very well.
But still it will be in the water.
Yes, yes.
So notice
Yes, my Lord.
Please.
which date?
Lordship, sir. Lord, I have one prayer. Lord, last time what happened, your Lordship knows by consent on 22nd, it was adjourned. And everybody had agreed that learned single judge would be requested to Lord adjourn the hearing. My lord, my distinguished friend, Mr. Raghavan was not in the court before your lordships. So before the learned single judge, he, my lord, stoutly resisted a request for adjournment. So it should be understood. Now learned single judge has kept it on 10th. Either your lordships keep before 10th, I have no problem. Otherwise, my lord, if your lordships are unable to fix it before 10th, then your lordships may, it should be understood by all parties that matter. Otherwise, it will become infractuous, completely infractuous.
Why infractuous?
Sorry, because the learned single judge is now brought post haste wanting to transfer the proceedings to
No, no.
CBI.
We do not.
That's the petition filed. That's what petitioners want. Learned single judge has issued notice on that.
How can you foresee a decision in any matter?
No, not foresee. The petitioners are insisting. Petitioners are insisting. So, my lord, I am respectfully submit. Either your lordships may protect me, or your lordship. It should be understood. I am in your lordship's hands.
My lord, can I make one submission? my
I am
lord?
seeking, my lord, ex parte stay today.
Can I make one?
Undoubtedly, because, my lord, I'll show to your lordships what wrong is there in learned single judge, which is hurting me very
Who are you,
seriously.
by the way?
My lord, I am a farmer who in 2004 sold this land to the Honorable Chief Minister's brother-in-law, not knowing what is going to happen in 2024.
Why you are?
Well, I've been, my documents have been set aside by the single judge. Single judge says I am party to fraud. Single judge says I am liable. Single judge says I should face prosecution.
Why you are so much bothering after this much years?
No, my lord, why?
It's not-
Why
it's
should
not-
I at this stage and age, my lord, face this?
That will examine. But
Lord, my life and liberty is at stake.
what Mr. Raghavan is saying, yes.
My lord, can I make one submission, my lord? My lord, the anxiety that my learned friend is showing with respect to the hearing on the 10th is in 20.2. Please see the order that has been passed by the learned single judge against which this appeal is filed. All that the order says is, my lord, issue notice.
No,
It is
see the
against
last
that
order.
That is all the order that has been passed. Nothing more. I ask myself, how is an appeal maintainable against an order simply issuing notice by the learned single judge? This is all that there is in
Lord,
it.
see the last order, Madam Court.
Please see, my lord. Please see the order.
I will.
Kindly see the last order.
That is
Learned
fine.
judge now has peremptorily fixed it.
That is 511 order.
No, subsequent order on 10th, 26, on 26.
My lord, what is challenged, my
The
lord?
understanding is matter would be heard on the said date. Now, my lord, they can't seek adjournment here. And kindly hear me on, my lord, ex parte stay. I'll pursue your lordships.
My lord, my objection is to the maintainability.
511,
I am
the
now
order was
saying,
that the Lok Ayukt is directed to place on record the investigation.
That's all.
Yes, correct, but my lord, it affects me. I am talking about Article 21, my lord. Why should I be condemned without hearing? Lord, it goes to the root. There are 100 judgments of Supreme Court which says that if you have not been heard, it must be set aside. It's a simple thing, my lord. I'm praying to your lordships.
Only
Nothing,
the
my lord, big.
record of investigation conducted till particular date is ordered.
If this judgment qua me goes, this order goes.
There is no expression of opinion.
Nothing.
No, nobody is saying. In this judgment, there is an expression of opinion.
My lord,
1713.
See, the
It's
matter
order.
coming
That
up.
is consequential.
No.
That is a second petition they filed.
Oh, you are saying that the proceedings may not go before.
Yes, please see this, my lord. Kindly turn to page 88.
We are the least court to interject in the proceedings of other court.
I am not wanting your lordships to interject in other court. I am wanting your lordships to protect me here. Please turn to page 88. Let us see what the learned single judge has done. Kindly turn to page 88.
Yes.
I am only on my, my lord, case and why, my lord, I should be protected. Page 88, my lord. Please see the first issue. My lord, this writ petition was filed by the Honorable Chief Minister challenging the sanction granted by Honorable Excellency the Governor under Section 17A of the Prevention of Corruption Act. It had nothing to do with the complaint. Now see first issue that learned judge framed. Whether the petitions before the Governor and the complaints before the concerned court were justified in the fact situation. Page 88. page 88, issue number 1. Whether the petitions before the governor, fair enough, that was the subject matter before learned single judge. And the complaints before the concerned court were justified in the fact situation. Now, complaint is against me also, I'm accused for. I'm not a party here. Learned single judge without any necessity, because the issue only was whether honorable governor was right or wrong. Now please see finding at 232. And before I show other pages, please see 232, Lord, straight. Please kindly turn to 232. Summary of findings. I have been condemned, Lord. I have no remedy now. The complainants were justified. 232, Lord. First finding. Complainants were justified in registering complaint and seeking approval at the hands of governor, or seeking. Registering complaint. Now, which, my Lord, trial court today will give me benefit? Now, see the findings against me at pages, my Lord, 93 to 97 first. 93 to 97, Lord. Lord, I'll tell your Lordships briefly what happened. Lord, this is just kindly give me five minutes, Lord. Lord, this is a land which has been in my family since 1935. Lord, in 1968, Lord, this land was relinquished by me in favor of my other brother, my elder brother. Then it so happened that elder brother went into debts. And my Lord, he passed away, unfortunately. His wife, son, and the other surviving brother, all of us agreed, appeared before the revenue authority in what is known as the inheritance khata, as my lords would tell. And my Lord, the authorities recorded that my brother's widow, her son, and my other surviving brother have now relinquished the right in my favor. The land was accordingly transferred in my favor. All these facts are suppressed from the court. And suggestion is being made that although you are not the owner of the land, you sold it in 2004. Now, which is incorrect because it is recorded on revenue and all the records are before your lordships today. I can show. Now, my Lord, that happened. Then, my Lord, the acquisition proceeding started. And before, my Lord, in respect of my land, an individual award was made. I had moved an application for withdrawal of the acquisition under section 48 for denotification, which was recommended by a committee consisting of large number of members, including members from the Bharatiya Janata Party, Congress, Janata Dal, everybody in Muda. It was sent to the government. A committee of 6 secretaries of government of Karnataka considered that, and along with some hundreds of cases, denotified my land. I am not the individual alone who is benefited. Now, if that be so, then, my Lord, that denotification. Now, see at page 97, what does the learned judge say? Please see. Lord, after recording, and Lord, unfortunately, the petitioners did not inform the learned judge of full facts, although they got, Lord, full record, but they selectively placed it before the learned single judge. So, Lord, I don't blame learned single judge for these findings. It's the petitioners who have misled the court. 97, Lord, just first at the top. Based upon the said proceedings, and notwithstanding the fact that the amount of award was also deposited before jurisdictional civil court. Now, Lord, civil court returned that amount, which they don't disclose. Civil court said that the amount is not deposited for individual plans. The land comes to be denotified. This, on the face of it, is illegal act on the part of the state. Now, Lord, denotification in my favor in 1998, learned judges commented in 2024. My right to property is seriously affected. It's a constitutional right under Article 300 capital A. And I have sold it for a valuable consideration under a registered sale deed in 2004 for 5,36,000 rupees. Now, Lord, please see at page 100. Please see. Page 100, my Lord. First paragraph, last 5 lines. Mudda does not stop at that. Continues to form layout and distribute sites in favor of allottees. From 98 to 2003, owner of survey number 464 is shown as Mudda. Encumbrance certificate also reflects Mudda. Upon date of acquisition, it reflected name of Mallaraya, nowhere reflected name of Devaraju. Now, this is absolutely incorrect because, my Lord, the land record shows my name again and again for various years. From from 91, 92, which was not, my lord. Here springs the picture, family of Chief Minister. I am not concerned, my lord. Devaraju, who claiming to be son of Ninja, para 21, executed a sale deed in favor of Mallika Jodnaya. He is a brother-in-law of petitioner. Sale deed is executed on 25/8/2004, but sites were formed. Now, my lord, sale deed in 2020 years ago, who knows what will be the value in 2024? Learned judge says in 1935, value was 300 rupees. It is today 56 crores of rupees. My lord, how am I concerned as a small man? Now, my lord, please kindly turn to page 104. My lord, the learned single judge, please see at the 103 foot. What is discernible from the sale deed is none of the factors that have happened from 92 are even noticed. Devaraju was aware that subject land was included in preliminary notification. He was award final notification included. He submitted representation for denotification. Passing of the award is within knowledge. Deliberately, all these factors are suppressed and a sale deed is executed free from all history. But the land was already denotified. What is there to tell in the registered sale deed? Right or wrong? Nobody questioned it. And, my lord, your lordships are aware, my lord may perhaps tell your lordships, that in Karnataka, my lord, denotification is nothing new. Because, my lord, the farmers represent to the government and the government considers it. Now, my lord, right or wrong, in 1998, denotification took place. 1998. Now, all right, if you want to, my lord, damn me, at least the learned judge should have told the parties that joined Devaraju as a party. So, my lord, without joining me, the learned single judge, my lord, has. Now, what is the, my lord, consequence? Show me that, compile it, this note.
I don't want to interrupt my learning. I have a small suggestion.
Show me this note.
This is a matter in
Quickly.
which, my lord,
It should have
that
ready
your lordships, my
in your
lords,
hands.
consider it right or wrong, my lords. If your lordship decides to issue notice, then, my lords, the matter will have to be heard. Right, my lords? Now, if your lordship don't want to dismiss it ex parte and issue notice, my lords, then let it be heard. Right, my lords? All parties should be heard at that point in time, my lords. Right? That's right, that's ideal. Therefore, my lords, we will all request the learned single judge, because this has ramifications.
Kindly give.
Right? Sorry, my lord?
We will not come.
My lord, kindly see the law. My lord, your lordships are aware, but my lord, as recently as last week, I was sitting in Court of Justice, Dipankar Datta, my lord, and lordship set aside an identical judgment of the High Court where, my lord, observations were made and decision given against a party who was not before the High Court. Now that law is settled, your lordships are aware. My difficulty is that I am a criminal complaint is filed against me. With these findings, my lord, the criminal complaint, I will have no defense left.
My lord, can I make one submission, my lord? The matter.
One second.
Yes,
All
sir.
arguments of yours are liable to be considered on merits in respect to your prayer to leave to appeal, but not in connection with the staying of the proceeding to a learned single.
No, my lord, once your lordships grant me leave, I have a right to pursue your lordships to protect me. I am not, certainly, my lord, your lordships can't say that once your lordships grant leave, my lord, it's a right to appeal. And in appeal, I have a right to seek stay. Please don't drive me, my lord, from one court to the other. We are only respectfully urging your lordships that please don't.
All are jurisdictional courts. You go there and whatever you request there, we are not coming in way.
No.
As Mr.
Lord, please see this.
Is Sibal is trying to balance the things.
My lord,
What I'm trying to
my
say,
lord, the learned judge, my lord,
all parties, because this matter has ramifications, my lord, it's not just this matter, connected matters have ramifications,
of-
right? So it should not be that the right to appeal is lost by some peremptory order passed by the learned single judge. That's all that I am, as a state, concerned about, my lords. Either way, I'm neither for, my lords, this side or that side. But, my lords, therefore, there should be an understanding that
but we are in
till such
entirely
time
in
as
your
your
lordship's
lordship,
hands.
till
Otherwise,
such,
your lordship may
till
decline
such-
me.
till such time-
I have no problem.
this time, no, once again.
If
till
your
such
lordships are
time,
not
all
persuaded,
parties should agree.
I am, Lord, I can't go beyond that. I can only persuade your lordships.
No, no,
Ultimately,
I'm
I have to bow
suggesting-
down. I have to bow down to your lordship's decision. But I need protection because, Lord, at 80 years, I don't want to face the criminal court. I don't want to face, Lord, police and CBI. Why should I do it? I have nothing to do with them. I sold it. Lord, if today as a lawyer I sell land to somebody and in 20 years later, if it's found that he is into criminal activity, should I be held responsible?
My lord, can I make one submission if my learned friend will kindly,
Only-
permit me, my lord?
The only apprehension probably would be, my lord, is it fixed at 10,
That's
10th
right,
at
a
2.
peremptory order passed by him.
Can
Yes.
no, my lord, I
Everything in
will tell your lordships, my lord, what
But
happened.
Raghavan, you should have joined me as a party. Why were you shying
One
away?
minute, sir, I am not
You
a,
didn't join me.
in which petition? I am not the petitioner.
No, you took, in your counter, you have made allegations against me. Despite the fact that it was governor's order, which was
I am
in
not the
consideration.
petitioner. Mr. Dave, I am
I will
not.
show your counter, Mr. Raghavan.
I am not the petitioner.
Serious allegations.
The petitioner is not me. The petitioner was Mr. Siddaramaiah. I was not
Petitioner
the
did not
petitioner.
do anything.
I was a respondent.
It was your counter which prevailed upon the learned judge.
Don't keep saying I should have made a party. How can I make you a party?
Mr. Raghavan, why are you not here today when we are here? I thought I would at least like to see you.
I would have loved to, but I had some other commitment which was a little unavoidable. Otherwise, I would have never missed being with you. And in the distinguished company of all of you, I would have loved to be there. Can I make one submission, my lord? If I am permitted.
Sorry, yes.
My lord, the only order that has been passed in the writ petition is to issue notice. My learned, whatever my learned friend has told your lordships, my learned friend can tell the learned single judge. And in the only prayer in that writ petition, which is coming up on the 10th, is to say, instead of having the Lokayukta police to investigate, please refer it to CBI. Whether the court will do it, will not do it, in respect of whom the court will do it, these are all matters left to the learned single judge. My learned friend may be very right in what he
If
says.
it is so simple, why don't you agree for an adjournment, Mr. Raghavan?
Sir,
You know what you are trying to aim.
Sir, let me complete.
We
sir.
all know it.
I am just.
It is a serious issue. It affects the liberty of a citizen.
1 minute, my lord. All that is high-flown words. All that I am trying to do, my lord, is to persuade this honorable court to simply leave it to the learned single judge. My learned friend, whatever he is saying today, can tell the learned single judge. Learned single judge will do whatever he thinks is appropriate. And now, my lord, against an order saying issue notice.
So if the,
My lord, what is this appeal?
if the,
What is this appeal?
if the request is
Yes.
made by Mr. Sibbal to learn a single judge on 10th, as he is suggesting, what you will do?
What I will do, my lord? I will
I
try
may
to
submit
persuade. I will tell your lordship what I will do. I will try to persuade the learned single
That's
judge
all.
to take it up.
We end here as far as commenting your suggestions are concerned, and we leave it to it. But we are not going to pass any.
Right, very.
We understand the anxiety, but still we are a different court. Not like to influence any proceedings.
I am only on my
Benefit.
appeal. Lord, I am on my appeal. Your lordships may kindly consider and record my prayer for stay. That's all. Your lordships may decline it, no difficulty.
Today we
But-
are at the stage of granting or not granting leave to appeal.
Lord, once your lordships grant the leave, if your lordships are not inclined to grant the leave, I will bow down. No difficulty, my lord.
Therefore, we are hearing all in that respect.
No, my lord, I am saying that you please protect me. I can't be without a remedy. My lord, if your lordships are not inclined, I have a remedy in the Supreme Court. My lord, I can't be left without a remedy. With greatest respect, let me tell your lordships, I am today vulnerable. I am, whatever Mr. Raghavan says, my lord, they are pressing before the learned single judge for hearing of the matter.
My learned friend will oppose my prayer.
And my lord, in the second matter, I am party.
In the second matter, the only
Lord,
issue
in the
notice.
second matter, I am party and I have filed appeal. There is no leave there.
All are fair lawyers, so.
So, my lord, either your lordships may request all parties to stay their hands off till your lordships decide it. We would be more than happy. One day is not hearing.
But he's not.
Heavens are not going to fall. 24 years it has waited. Why should not my learned friends insist? What will they do? Lord, just look at it. The Lokayukt court issues a process, a direction to the police to investigate. As soon as that is done, a petition is filed on the same day before the learned single judge CBI. Now it is at their prayer, at their petition for Lokayukt investigation that Lokayukt court intervened. And Lokayukt police was directed. Now he moves the single judge by a writ on the same day and says now CBI. Tomorrow he will say now ED. Third day he will say something else. Well, are we going to be subject to these kind of vexatious prosecutions? It is a vexatious prosecution so far as I am concerned. I am not concerned about the Honorable CM and others.
By making any observation, we would not like to enter the mind of learned single.
No, I am not saying that. Your lordships may protect me or request the learned single judge.
But whatever we observe in black and white or even orally, it will influence the proceeding there. That we don't want, very clear.
Certainly, but your lordships want learned single judge to proceed, then kindly,
Nobody prevents from you to requesting. And no.
Lord, why should I be? I am before your lordships. I am seeking your lordships' indulgence in the second matter. Kindly grant me stay or say no. Lord, your lordships can't say that your lordships will not be able to protect me when we are saying it has been peremptorily fixed at 2:30. And my learned friend, despite last understanding, resisted tooth and nail. Mr. Maninder Singh, his lead counsel, agreed before your lordships. And it was because of a very joyous occasion in his family that we all agreed.
My lord, I think Mr. Dave can control himself as far as our domestic affairs are concerned. It's very unfair on his part.
What is
it was unfair on that day. There is no need to tell what is happening in our domestic affairs.
No, you did agree. That's all I'm saying.
No, but there is no need to add some qualification to that. Last time also you did it, I didn't say anything.
What is
this
wrong?
My lord, this is a Noora Kushti going on between two parties. One doesn't bleed the other and the other comes up and asks for stay. It is a pure Noora Kushti going on.
Very well. You know what you are doing by filing this so-called
Yes,
public
we know.
spirited petitions.
Yes, we know. Yes, we
after
know.
24 years.
We know.
Said better, Mr. Maninder Singh.
Yes, please, let's set the better. You should have stopped yourself.
You move SLP. Don't worry.
Lord, I am appearing in the Lord, first matter.
9th is what day? We can request lordship to. What your lordships can fix. Or your lordships can fix it on 9th itself, if your lordships like.
But it is not that, my lord, he's made an accused pursuant to the order of the learned single judge, my lord. Much prior to that, complaint before the Lokayukta inspector and subsequent complaint before the Lokayukta SP and a private complaint before the special court, my lord. He's been shown as the accused. It's not, my lord, pursuant to the judgment passed by the learned single judge that is now being made the accused. That's not so.
Exactly.
It's being portrayed as though he's being now freshly made the accused
No,
pursuant to
that's
the order
correct.
passed by the learned single judge.
You are absolutely right. I agree with you. But with the observations and findings of the learned single judge, I will have no defense left. That's my request.
But these are not observations, my lord. These are mere contentions.
No. What are you
Have been
saying?
observed.
With great respect,
These
don't
are
be
not
uncharitable to the learned single judge. These are findings.
My lord, may I-
categorical findings of facts.
If it is, my lord, we will examine, my lord, as to whether any findings have been recorded by the learned single judge against Mr.
You should
Dave's.
have read the judgment
My
by
lord, we
now,
will have a
Mr.
look at
Raghavan.
it, sir. I mean, it can't be rushed like this. My
No, the
lord,
developed layout,
Your
my lord,
Lordship,
the
may kindly
developed
this-
layout was
this order-
alienated, portraying as though it's an agricultural land.
and this order, my lord, was passed 2.5 months ago.
This 80-year gentleman is totally involved in the fraudulent activity.
Malas, I've been disabled from the video in item 20, Malas.
Yes, the other appeal, item 20, Malas, Dr. Singhvi is appearing. I'm for the state.
Please.
Yes.
Same, all are appearing except for
So
the
all the
down now, my
caveat
lord.
is, my lord.
Same order needs to be issued in all three matters. my lord. Please, my lord. In first and second matter. my lord. Please, my lord. In the third matter, all are represent, except for my lord. Notice will have to go, my lord. Notice will have to go, my lord.
In fact, for His Excellency the Governor, the Solicitor General has already taken notice. Court may kindly recollect, it was at his instance, the matter was urgent. No, when the date was fixed, a mention
But we
was
jointly
made.
agreed on 5th.
He mention was
Should
made.
have all been here, my
At
lord.
his instance.
We
court was
agreed.
Pleased to.
No, notice,
an agreed
formal
date.
notice has to go, my lord. Formal notice may have to go, my lord.
Very well. Very well.
Can I, if I may request, my lord, in WP number 1719, notice may have to go to, there are quite a few respondents, my lord. The first.
What is 171?
Which date do you propose next?
Whatever your lordship.
We would like to have it done as quickly as possible.
Because this will at least
Take some time.
take time for hearing.
Definitely some time it will take.
Malas, your lordship will hear me on 20,
What
Malas.
is your main of submission, main matter?
My main.
Item 20.
Malas,
Sorry,
I'm
not
for the
yours. The
state.
main petition. Who is
That's
appearing?
Malas,
Dr.
Dr.
I appear for Dr. Singhvi.
Well,
is also-
my
he's
video was
appearing.
disabled.
He's-
Now, can I, Malas, make my
What is the
submission?
main plan?
Yes. May I make my submission in a coherent manner for 10 minutes?
Yes,
With your lordship's kind permission.
Just highlight, nothing more. Than
Yes. Now, Malas, I am here and I would be using only two documents. Malas, one is a list of the finding of the learned single judge and the error thereon. And the second will be the written submission in more elaboration as to why that's an error. Now, the principal error are the following, Malas. Number one, that your lordship's, Malas, has got a 17A situation here.
Is it about the validity of the consent itself?
Yes.
Or is it,
It is about
the-
two or three things.
Or is it
First
about
is-
it
Yeah.
about the scope, implementation and the
No, so let me explain.
import
Let me explain.
Article 163. What is?
Let me, I just started, give me a few
The
minutes.
state, I'll
It is-
just take
it
about
is-
5 to 7 minutes after he has finished and give your lordships a gist of what the issue is. Let him finish.
So, Malas,
please.
as far
I
as
don't want
I'm
to
con-
interrupt.
So as far as I'm concerned, Malas, for the appellant in item 20, my submissions are these.
Yes.
First, Malas, is that 17A has been completely violated. The requirement and mandate of 17A that there has to be a filter of a police officer has been violated, and despite that wrongly upheld by the learned single judge. A private complaint, Malas, or any other complaint must go through the filter of a police officer is the first submission. And 17A has been completely violated. Here he has gone straight to the governor. Number two.
You need not. 2 years.
Number two. Well, and this is a very large and a very serious constitutional issue. Well, it's the law generally decided even by constitution benches till last year, Subhash decided, is that the governor is and must be bound by the aid and advice of the cabinet. Number two, there are well-known exceptions to it. It is not that he is always bound. One exception is if there is clearly,
in this case, whether it is a subjective discretion.
No,
or
therefore,
constitutional-
immediately, allow me.
Or constitutional discretion. That is-
Exactly. Now, let me. Here, Malas, I am now coming to the exception. The exception is where there is manifest irrationality, where there is manifest irrationality, that's the word in the test used by the Supreme Court, in the sanction, refusal or order regarding sanction by the state government. Now, Millets, the learned single judge on the contention of the other side misreads that exception.
So manifest irrationality in sanction.
If there is manifest irrationality in refusing sanction or granting sanction, then it is in the cabinet policy. Then the governor may interfere. That is the law generally. However, the learned judge upholds the sanction or the approval on the short ground. A, that the state government is an interested party. B, that if the chief minister heads the government, by definition, ipso facto and ipso jure, he must control the entire cabinet. And most important, even following the MP police judgment.
Broad outline of your.
No, I'm trying to. I'm not even taken 5 minutes. Or even for a broad outline, I require 5-7 minutes. Because it's not the kind of case where I can encapsulate. But only I'll take 5 minutes, 5-7 minutes, because it's really important.
Yes.
Now, even as per the case, they have set up MP police establishment. A manifest irrationality is a test. Now, the learned governor's order nowhere points out or attempts to point out manifest irrationality. Nothing. What happens is a very strange thing. When the hearing is going on in the learned single judge, the governor or his office, without filing any counter, any pleading, files charts purportedly summarizing his file notings, showing that such a long note was made about the matter. First of all, Malus, charts are no substitute for pleadings.
Mr. Singh, we don't stretch so much that it amounts to ex parte hearing.
Very well, Malus, I am interested only in one thing. If your lordship, very well,
broad general outline of your.
Very well, very well.
So,
Malus, yes. So these are the two broad heads. There are other.
Your appeal memo also, but it just we wanted to.
Yeah, very well. Well, therefore, let me, if your lordship, let me just put another point there very briefly.
So,
broad heads are these. Give me 2 minutes, Malus, 2 minutes. There are broad heads are these. There are other nuances which I'll not argue now.
Better in after holiday.
It is certainly not a case which does not require notice. If it has notice, your lordship will have a deferment of the 10th date. Nobody is running away anywhere. If Malus, the matter is so useless that your lordship did not issue notice, that's a different matter. But if your lordship is issuing notice or considering it, it is Malus a balance of convenience and irreversible prejudice.
Undoubtedly,
Stares us in the face. That
Well, my lord is saying, my lord, the Chief Justice is saying it's undoubtedly a matter for notice. You don't have to labor on that.
To be heard at reasonable
exactly,
length. There is no doubt.
Well,
No, Mr. Simple, I'm not on that. I'm on the
May I at
subsequent
least have
request.
one prayer? Your lordship may say it should be finally disposed of.
One supplement.
That would be.
May I make one submission?
It should be
I had
understood.
supplemented Dr. Singhvi before the learned single judge. Only 2 submissions. Number 1, possession of the land was never handed over to Muda.
Not going in any.
No. That's a critical factor. Because the learned judge says
It will not be fair on our part, nor will be fair on the part of
the learned judge has recorded a finding.
The parties who are not present and who are subject to be noticed, yes, yet to be subjected to notice. So don't make elaborate submissions.
No, not elaborate. Only 2 aspects.
No submission.
Number 1,
Without
layout was forum.
Without submission, we are issuing notice. What more you want? We don't want any elaborate submission. Today we will hear it at length.
That there is not a whisper in the entire judgment. I have argued this proposition.
So we'll hear everything, every aspect of the matter.
There is not a whisper.
Second week of January, some date, my lord.
It is the
Second
foundation
week of
for the
January.
whole case. No
Around the
possession was
14th.
taken.
or
Malus, 13th.
week of January.
13th, Malus, 13th.
13th is a Monday, my lord. I think
No.
Delhi lawyers would.
14th.
No, 13th is not a working day, sir.
Here.
No, Mr. Dave.
14th January, how can your lordship not be in Gujarat?
No, 13th is working.
I have left flying kites. I've given up flying kites.
In a
I'm
lighter
talking
vein.
13th, not
But
14th.
in something.
All in light.
Justice Shah used to make it a point to go. Justice M.R. Shah, his lordship then was. He used to
Anything
make it a
connected,
point.
my
to-
lord, my lord.
I just want 5 minutes. I'm really forgetting about the merits of this matter. I tell your lordships, the real issue that arises in the case. And this doesn't apply to this government or that government. It applies to the constitutional position of the governor. I make a complaint against a minister, against the cabinet minister in the government of India or the state minister here. And the governor says, I give approval. Right, it can happen in any case, Mullahs. We can merely on a complaint, right, Mullahs? But under 17A, the word uses prior approval. Approval means approving something that has happened. Not a complaint. A complaint is an allegation. So the conspectus of the word approval. Otherwise, in every complaint, a governor in any state will order a prosecution.
To the inquiry.
I'm sorry?
Approval to the inquiry.
Correct. I'm talking about approval. Any approval requires Mullahs approving something that has happened. Right? That exists. Now, in normal cases, it's an inquiry that has already happened and you give approval. In sanctioning matters, Mullahs, there is a whole set of procedures that go on, Mullahs. Forget this case. I'm just telling your lordships the broader issue. So, Mullahs, you have to have an approval of something that's already happened. But if the governor has the inherent power to order an inquiry on a complaint, that can happen in any case, any minister in the country. Right? That's an issue not discussed anywhere. It's a real constitutional issue. That's number one. Number two, Mullahs, if your lordships will remember in Narsim Rao's case, Mullahs, before the Constitutional Bench, I myself argued it. Mullahs, the question arose that the sanctioning authority has to be the authority which appointed the person. That's because that's the authority that can remove him. So I argued that a member of parliament is not appointed by anybody. Not appointed by anybody. So who is the sanctioning authority? So because they could not find any sanctioning authority in the Prevention of Corruption Act under Section 19, so they said the sanctioning authority would be the Lok Sabha Speaker in the case of a member of parliament on the Lok Sabha and the chairman of the Rajya Sabha, because nobody else can remove him. Right? I'm sorry?
Speaker can remove.
No. Speaker will come to the conclusion that he is disqualified.
Disqualified.
That's right, after an inquiry. Therefore, he's no longer, that's why, because there's no statutory provision. Now, in this statute, it says sanction will be granted by the authority that appointed him, which also has not, this is a much larger constitutional issue. No, nobody appointed him. Nobody appointed him. So who is the sanctioning authority? It's the Legislative Assembly.
So according to you, the
governor has no
Chief
jurisdiction.
Minister is not appointed by.
It has no jurisdiction.
You are saying that Chief Minister is not appointed by the government.
No. I'm saying that to prosecute him, the authority concerned has been the authority. That's Section 17A. Just read it for a second. Just read 17A. These are very serious constitutional issues. See the last case. First, it is no police officer shall conduct any inquiry. Your Lordship has that? Or investigation into any offense alleged to have been committed by a public servant under this act, where the alleged offense is relatable to any recommendation made or decision taken by such public servant in discharge of his official functions as duties without the previous approval. The word approval means something has happened, not a complaint, not on a complaint. Right. Now just leave that. That's the one constitutional issue. Second, C, kindly see.
Yes. C.
In the case of any other person, because one is a government servant, Mullahs, right? So C will apply in the case of any other person of the authority competent to remove him from his office at the time when the offense was committed. Offense was committed when? In 2021-22. He was the leader of the opposition. He was not a chief minister. And who can remove him? Constitution bench says only the speaker. What jurisdiction does the governor have to even entertain this matter? Okay. not decided by the single judge. Right? That's number two. Number three, another constitutional issue. In the Arunachal matter, Nebia, sorry, Nabam Rebia, which again I argued, Maharaj, the court said that the governor has only three discretionary powers. What are those three? Number one, if a bill is sent to him, he can return it. He can refer it to the president. Correct? Under 356, the second discretionary power, he can say governor's president's rule should be imposed. He doesn't have to consult the council of ministers. And the third discretionary power is under the sixth schedule, 371. As your lordship knows, that discretionary power was when he was governor in Assam, then extended to Sikkim, extended to Arunachal. He has certain discretionary powers under the sixth schedule. Other than that, he has no discretionary power.
Samsher Singh also said that.
Sorry?
Samsher Singh also.
Yes. Yeah, no, but.
Samsher Singh, the main first said.
Yes, but that was different, Malas. Here they are considering Article 163, which your lordship, my lord, the Chief Justice mentioned in the beginning, right? It's in that context that the court said, other than that, there is no power under the Constitution. No, these are constitutional issues. This is not a matter, Malas, of A Chief Minister or B Chief Minister or A Minister or B Minister. It affects the polity of our country. And if you are going to prosecute chief ministers and ministers in this context, Malas, there will be complete chaos. I am not, Malas, supporting A or B, Malas, but this just cannot be done. So, Malas, these are issues that have to be decided. Later. Yes, that's all, Malas. Therefore, the issue, therefore, Malas, we should all, it should not be that the writ petition gets decided, this becomes infructuous. Well, that should not happen.
So, Malas, therefore, I
don't want to say anything more than that.
Malas, before I was interrupted, I was trying to make a point without going into the merits. Would your lordship give me 2 minutes to make that point in item 20? Can the Honorable Chief Justice hear me?
We are really not indulging into hearing of them.
No, I just take 2 minutes for saying something else. Your lordship has rightly said that this is a matter deserving notice.
No, this is all loud thinking. Rightly or wrongly, we do not know, Mr.
No, Malas, I am only saying.
This is all loud thinking.
I am only saying.
When we are considering issuance of notice, nothing more, nothing less.
Therefore,
no
Malas,
opinion expressed, no merit is gone into. This is all just.
No, Malas, if your lordship is issuing notice.
This is the way we converse and enjoy the conversation.
No, Malas, I am saying something else. Allow me to say that, Malas, 2 minutes.
Yes.
That is this. Malas, the principles of balance of convenience and irreversible prejudice apply after your lordship issues notice. Your lordship is kindly considering issuing notice. All I'm saying is that there should be no situation where the balance of convenience is rendered irreversible. We are not, nobody can run away. It's only a deferment of 10th to January. Now, Malas, if it is said that while your lordship is in scission of the matter, my learned friends on the other side say no, and the matter goes on, then really, Malas, the scission of this Honorable High Court is being diluted. Heavens will not fall if the CBI court hears the same thing in January. That is the point I'm trying to make, Malas. If it was a worthless case, frivolous, false, or vexatious, without constitutional issues, your lordships, Malas, would not be entertaining it. But if it is being entertained, your lordship should consider that, Malas, either by consent or by an observation, or Malas, I will make a statement here that we will move them. But Malas, there has to be some acknowledgement or recordal of that statement in the High Court. Otherwise, if the CBI court goes ahead, then it is really an exercise in rendering my entire proceeding infructuous or futile. That is the respectful submission. And your lordship does it routinely, Malas, for balance of convenience considerations in every case. Because ultimately your lordship decides in next month.
Your voice, sir, is not reaching us, Mr. Maninder Singh.
Lord, I was not. Lord,
now, yes.
Lord, I was only making a humble submission. We are not joining issues, my lord. Your lordships have been decided to issue notice, my lord. We'll assist your lordship. But, my lord, an order passed on 24th of September only ordering for investigation, my lord. These sides, my lord, we will make it good, my lord, that these are only colluding with each other to somehow get a interim order. So, your lordship will just fix a date, my lord. Matter finally needs to be heard. That's all.
It shouldn't be
One is
ignored.
asking for the other. by creating an artificial distinction. They are all hand in glove.
My lord, can I make one submission, my lord, with respect to the submission that was made for deferring the hearing of 10th of November? All that was told to your lordships, my lord, my learned friends can say it before the learned single judge. And the learned single judge, my lord, will take one view or the other on that matter.
We don't
There
want
is-
any legal
My lord,
advice.
my
We
lord,
don't want any legal advice
please,
from
my
my
lord,
learned friend.
I'm-
We know
I'm
what to do.
my lord,
We
I'm
are
making
pleading before this honorable court,
my lord,
our
I'm making a
difficulty.
submission to
We
your
don't
lord.
want any legal advice from
I
our.
am not giving you any legal
Sorry,
advice.
sorry.
Please.
No, we don't want any legal advice.
I'm
from
not,
you.
I don't have
Sorry,
the capability
we
to
are
do
not
that.
here to take any legal advice from you.
I am not giving you any legal advice. I'm making a
Where he will resist tooth and nail, my lord. I can assure your lordships.
I-
And I'll come back again before your lordships.
Very well. Whatever happens, my lord. All that was done by the
Multiplicity of proceedings. I don't understand why your lordship
My
should
lord,
not protect us.
my
Pending
lord
appeal.
will
If your
give me the
lordships are
same.
inclined to issue notice, your lordship should protect us.
My lord,
Otherwise,
my
it becomes
friend will-
operation successful, patient dead.
My lord,
No, no.
will give me the same.
What is the
courtesy.
point?
My learned friend will give me the same courtesy as
Anyway,
extended
Mr.
time. of-
Raghavan, if you want to drive us to more litigation,
Please,
we'll be happy.
Mr. Dave, let me have the pleasure of addressing the court without your interruption. My lord, all the times,
You
all
don't
the
want to fairly agree, Mr. Raghavan, that you will agree for deferment. Do you understand that?
My lord, no, I'm not.
And we know why.
I'm making it clear to my learned friend, I am not giving any consent today. All that I'm saying is, my lord, is the only order that has been passed in that writ petition is issue notice. What the learned single judge will do thereafter, he may even dismiss the writ petition, he may allow the writ petition, he may defer the writ petition, we never know. To therefore, my lord, to jump to the conclusion today, as my learned friend is saying, why should I face a CBI court? He's assuming that the court is going to refer to CBI. The court may dismiss my petition. We don't know. So therefore, my lord, I oppose any judicial order with respect to, my lord, deferment.
Lord, in state, my lord has raised the issue of competency, my lord.
It's
14 January. is
14
fine.
Jan. 14 Jan. man.
So can it be 13th?
I have no problem on 13th, my lord.
13th?
13th.
Obliged.
Please,
Mullah, the lead counsel is Dr. Singhvi Mullah. I'm just an appendage. His preference is.
Well, nobody dare call Mr. Sibbal an appendage. That is being excessively humble.
He always has his own
Excessively
dates,
humble.
so we shall abide by his dictum.
My lord, whatever may happen between Mr. Sibbal and Mr. Singhvi,
14th is a holiday.
we want both of them in our court.
14th is a general holiday in Karnataka.
15th.
13th.
13th is fine.
My lord, as I indicated, my lord, whatever may happen between Mr. Sibbal and Mr. Singhvi, we want both of them in our court.
I think your lordships will
Sir,
try
it's
to
a
fix
big
it for 2
festival.
or 3 consecutive days. So give in
13th.
such a way.
So let us start on 13th, Mr. Dave. Let's start on
Sir,
13th.
it's a big festival.
But
It's a-
Dr.
Yes.
Singhvi, let it be consecutive days. Otherwise,
No,
there
I
will be a
don't mind,
problem.
but let it start on 13th. No? Then there's a small gap after that.
So 15th then, 15th. Fine.
please, please.
No, about
please,
15,
please.
16, 17, 3 days we'll get. Because it won't be over in one day. Lord, large, unless your lordship separate me and hear me separate.
My lord, I have some
great issues.
inconvenience on 16th and 17th.
Not 16th.
I will enjoy the debate, but I am the sufferer.
No, but that's-
My lord, 16th and 17th, I have some difficulty. Can it be
Oh, God.
some date, my lord?
Then 2026 only.
No, Malas, then Malas workings. May I request, well, there's a working Saturday on 25th. We can start then. If it's going to the next week because Mr. Raghavan is not available.
21st would be more of.
Yeah.
Can it be on 29th and 30th if it is convenient to everybody, my lord?
No,
That will be too
25th.
far.
You all want continuous hearing? You want continuous hearing?
I would say so.
Mr.
I'm
Dave.
entirely in your lordship's hands.
No, Mr.
Sorry,
Dave, can
your
I
lordships.
request?
Subject to the other side will be appearing.
Please.
Can I request? 25th is a working Saturday.
20th,
Any date, my lord. We will be here.
2-5.
We'll be here.
2-5 is a working Saturday. Malas, kindly consider that.
20th.
2-5. 25.
25 also no, 25 January.
Yes.
That will be too far off, Dr. Singhvi.
That's okay.
Then have it on 13th. You agree to either 13th or 25th at least.
And Mr. Raghavan is not on leave on 10th.
No, 13th. 13th.
It is all right. I am okay, madam. I want to have the pleasure of being in the company of my learned friends, my lord. That's all that I am requesting.
Very well, then please put it on 13th, Wallace. We'll
13th, I have no objection.
13th. Very good.
I told your lordship, Dr. Singh, we will have his way on dates. There is no way we can resist that.
13th feasible.
13th.
Please.
Your lordships may say matter will be finally disposed of.
It is, we are proceeding for final hearing only. What more?
But then, Lord, your lordships may record my prayer for stay.
No.
Because I am genuinely worried about my fate. That's my. If your lordships were to say to be finally disposed of, at least I can persuade learned single judge not to proceed.
In the sandwich day, there will be break in the here. Interruption.
Let us begin on 13th,
Let's
no
begin on
difficulty.
13th.
Then 16th.
Let's not plan.
the next
We'll
day.
start on 13th, Wallace. We'll
Yes,
see
we
that.
start on 13th and then 16th onwards.
16th.
Mullahs,
Dr. Singhvi is keen on 13th.
Mullahs, 16th, 17th.
We'll adjust later on. After 13th,
Already
we'll adjust.
committed matters in
Then
Supreme.
20th.
So we'll
20th
adjust.
is all right. 20th is fine.
20th.
Yes.
2-0.
Yeah.
We'll pass the order of notice.
Grateful.
Grateful, my lord, deeply obliged.
Grateful.
So that contentious is solved or not?
Yes, please, record all consent that it be heard on 20th.
No.
No.
Hold on.
The most contentious issue.
But your lordship notes, Wallace, after telling your lordship 3 times that I will have my way on dates, I have not had my way on dates. Your lordship is not given either 13th nor 25th.
That would also become contentious, whether you had your way or not.
No. I am requesting Wallace again because I have the first matter. If it can be 13th or 25th. That's all I was saying, but I have the first matter.
20th. Grateful, my lord. We can.
Grateful.
My lord, only thing is in first 2 matters, my lords.
But your lordships may grant leave in 1713. 1719, I am already a party, so there is no difficulty.
No, notice will have to go.
Please, my lord.
Yes.
Even for granting.
I'm sure they are not opposing leave. Mr. Raghavan, are you opposing leave?
Sir,
To
let
appeal?
I don't want to take a stand now.
Thank you.
So there will be common order. 20, 20.1 and 20.2. 1569 of 24, 1713 of 24, and 1719 of 24. Preferred by the original petitioner, the first capstan appeal under section 4 of the Karnataka High Court Act 1961 arise out of judgment and order of learned single judge. Dated 24th November 2024. In writ petition number 22356 of 2024. Our learned senior advocate, Mr. Abhishek Singhvi, assisted by.
No, I am also appearing. I am not assisting.
With, not assist, with.
With Professor Ravi Verma.
With learned advocate, Ravi Kumar.
Ravi Verma.
Ravi Verma. For the appellant. Learned Senior Advocate, Mr. Kapil Sibbal, assisted by or with whom?
Please, my lord.
You are also for state,
Please, my lord.
as well as Learned Advocate General, Mr. Shashikaran Shetty, for respondent one state. Who is for number 3? Learned Advocate so and so appears for respondent 3. Who is for number 4? 4.
I appear for 4, my lord.
Learned Senior Raghavan appears for number 4. And Learned Advocate Mr. 5. What is your name? Good name? Prakash, so and so. 5. Upon service of the copy of the appeal in advance. It was sought to be highlighted on behalf of the appellant paragraph that issues arise in the appeal which are required to be addressed at reasonable length. Full stop. Notice returnable on 20th January. Respective learned advocates appearing for the parties as above accepts the notice. The rest of the respondents shall be served before the next date, before the returnable date. And next paragraph, writ appeal number 1713 of 24. That is for what? 1713. That is for your appeal.
Yes, 1713,
Is for leave to appeal.
leave is to be granted, and 1719 is direct. appeal.
Filed by a third party seeking leave to appeal. The case put forward is that the land in question, which is dealt with in the judgment and order of learned single judge dated 24 September 2024 in relation to its grant to the appellant petitioner of the first captioned appeal, originally belonged to the applicant seeking leave to appeal. It is further pleaded that the applicant is desirous to prosecute the appeal against the said judgment and order, by contending that he is correct in the litigation on the aforesaid score that the land originally owned by him.
And his family.
And his family. There is no gainsaying that the substratum on which the plea for leave to appeal is based has linkage with the central challenge lodged in writ appeal number 1569 of 24. Paragraph. In the aforesaid view, notice in this appeal as well. In this appeal also returnable on 20th January 2025.
There is a delay of 7 days, Lordship may conduct.
Oh.
Notice on delay.
Notice in delay in both.
Delay can be condoned 7 days only.
Formality of appearance.
Very well, my lord. We'll face it.
Notice in delay application as well as appeal both. Leave to appeal application both in delay condonation application as well as in application for leave to appeal. The third.
Lord, 1719, that Lord goes with it only. All will have to be heard together.
179 is against the order of learned single.
Yes, it is.
Where is that 171?
Malas, there is one request I have.
Just a sec, Dr. Singhvi. Just a sec.
Yes, yes, Mr. Singh.
After your lordship is finished dictating.
Pardon?
No, after your lordship is finished dictating, I thought your lordship had finished.
No, you can tell if it is something.
No, Malas, I am saying this. Malas, I am in the first matter I have to open. 13th, 25th, 22nd, none of those 3 dates have been given. I'll be in a quandary. The other side is okay. Mr. Manindra Singh is okay. Mr. Raghavan is okay. Your lordship may consider either 13th or 22nd or 25th. And as far as going ahead is concerned, any date Malas can go ahead on. That should not deter us from starting on 13th or 25th.
25th Saturday, Malad. 25th Saturday, I think.
It's a working Saturday, Malas.
25th Saturday is a working Saturday, Malad.
January.
January.
I'm saying any date of these 3 dates.
25th, Malad.
Yes, all the dates taken are not.
Saturday, Malad.
So not
Yes.
25th.
25th Saturday.
Obliged.
My
Deeply
lord, the only
obliged.
request I have, my lord, is that on that day, my lord, I have some difficulty, but the case can go on, my lord. Please accommodate me another day.
That's a very kind of Mr. Raghavan to be so accommodative. I'm grateful to him.
How can I afford not to be that, sir, with you?
No, it doesn't always happen.
You all are the counsels busier than the court.
No, well, it's 25th is all right. Kindly accommodate 25th.
But we can't help. We'll start with Mr. Singhvi.
Very
Obliged. Obliged.
We started 2:30 so that it is not finished.
Finish, please.
So that we are in difficulty.
Deeply obliged.
And we'll be in difficulty.
No, this is our lighter vein. Whenever he starts, we'll start in order.
So we'll be here, my lord, whichever date you're on.
Yes.
25th
So,
Saturday.
The third caption, the writ appeal number 1719. Filed by original discipline number 12 in the writ process. Filed by appellant who was original discipline 12 in the writ proceedings.
Mr. Raghavan appears for respondent number 1, my lords.
Which is the challenged in which, the challenge in which is addressed to. Which order? Order dated 5/11/20.
Yes, my lord. That's
Yes,
5/11.
5/11.
Issuing notice.
One single judge, which is an order in the pending proceedings of writ petition number 27484 of 2024, whereby learned single judges has issued notice.
I'm seriously affected because of that judgment, previous judgment. That's why, my lord, I am before your lordship.
It was pointed out to the court that the prayer in the said writ petition is 6. The petitioner in the said petition 6, a prayer for inquiry by CBI.
Yes.
Yes, ma'am.
In connection with the subject matter.
In respect of a complaint, what is important is because the complaint is against me, which learned single judge has now finally decided in my respectful submission against me, us.
In respect of the subject matter, which is
Complaint before the Lokayukt court.
in respect of the subject matter
It's the legislative
involved in the
legislators.
main appeal. Number 15. What is that? 1569 of 2024. There shall be notice as well in the said appeal. Full stop in appeal number, in writ appeal number 1713 of 24 and.
Who's our one?
Only not the appearance and then waive.
Yes,
After.
yes.
Mr. Raghavan's client. Mr. Raghavan's client is on caveat. That can be dispensed with.
No, will not appearance in all the appeals and pass.
Not-
Please, ma'am. Please.
That's all.
Please,
Deeply
ma'am.
obliged. Deeply obliged.
Mr. Singh, at last, my lord, Mr. Singhvi had his day, my lord.
Now, don't trigger the things.
Exactly. We'll have more discussion on it, Mr. Raghavan.
Please maintain that.
That's not very unnatural
Mr.
considering I'm opening the first appeal.
Mr. Raghavan, you didn't say one thing, that the Honorable Court noticed that I was agreeable to every date which was suggested by Mr. Sibal and Dr. Singhvi. For you.
No, I am saying so was Mr. Raghavan also.
Grateful.
We are in a very, very heavy atmosphere. Therefore, lightness is.
Absolutely.
He's all in lightness, my lord. He's all in lightness.
Before we part, I must say one thing.
Nothing in the God.
Lord, before we part, I must say one thing. Lord, both Mr. Sibal, Dr. Singhvi, myself, we have had great privilege of appearing before this court. We respect and love this institution. Lord, I must say, he is currently the president of the Supreme Court Bar Association. I have been a president 3 times. I must say one thing, Lord, with all seriousness and Lord, with respect to my greatest friends, former president and current president of the bar here, that bar and bench are same side of the coin. And we are a family. And whatever we have, we must sit across and as a family resolve it.
Absolutely.
So thank you very much. So this
Very
is
good.
Deeply
Grateful to Malord.
Grateful,
this
Lord.
is the-
Grateful.
This is the order with correction in terms of the appearance.
Grateful, Lord. Grateful.
Grateful.
Take this.
Number 21, Mr. MC Basaraj. Fresh data.
Lord, appellant was a driver on the charge of unauthorized obscene, Lord, he was issued a charge sheet and disciplinary proceedings have been initiated. And the inquiry officer submitted his findings, holding that the charges leveled against the
The appearance. Head into your. Also money. Yes, what is that?
Lord, before going into the, Lord, there is a delay of 300 days.
Notice,
Please,
notice written.
please,
It will be February. 5th February.
please.
Number 22.
Lord, I appear not for the appellants. Lord, the order challenged is an order of the learned single judge interfering not with a part of the order passed.
Yes, ma'am.
The electricity utility, my lord, which is a state load dispatch center, is the appellant. My lord, the first respondent was the writ petitioner. The challenge, my lord, was to Section 11 order. Your lordships may recall that matter had appeared before your lordships, my lord, the validity of the order passed. During the pendency of the appeal, the Section 11 order was withdrawn. So, my lord, the question arose before your lordships whether anything will survive in the appeal, because the learned single judge in another case, my lord, had struck down that order. My lord, in this case, the initial challenge was to the entire order. When the learned single judge's order striking it down was brought to the notice, the writ petitioner confined it only to one aspect, my lord. My lord, it's very common commercial practice and also in the electricity sector that whenever a payment schedule is there, my lord, under the Section 11 order, any energy, all energy should be generated by this wind energy bagasse plant. Not this is a non-conventional energy fuel. So they have to supply it compulsorily to the state. The state, my lord, in the government order fixes a rate. Now, in that fixation of the rate, there was a early payment rebate. Now, the normal time for making payment, my lord, is 30 days. But this gave an incentive that if the utility pays the money before time, then a 2% rebate would have to be offered. So this is very common, my lord, commercial practice. The learned single judge, my lord, has interfered with that and struck down that clause. Now, meanwhile, my lord, what happened is proceedings under section 11(2), my lord, were instituted before the Electricity Regulatory Commission. The commission, my lord, has examined all this and has approved a particular tariff, and that has now got to be implemented. So this order, my lord, directly interferes with the role of the Regulatory Commission in fixing the tariff. There is a, my lord, a short delay, my lord, of 77 days in filing this appeal. So, my lord, my request, my lord, is that your lordships may consider, my lord, in the meanwhile, my lord, issuing notice and directing that no precipitate action shall be taken. Otherwise, my lord, they may force me to make a payment.
There is no contempt so far filed.
Not yet, my lord, not yet.
Then we'll keep the reopening immediately, 8th of January.
Please, my lord.
Notice returnable, both notice in relay conversion application as well as in appeal.
Please, my lord. Lord, if they take any precipitate action, your lordships may give me liberty to move, my lord.
You can move.
Very well, please.
I accept notice for respondent number 4 in the matter.
Learned advocate, Miss.
Sanction.
Waves accepts notice on
I
behalf
take
of
notice for R3.
4. Where is learned additional?
R3, my lord, respondent number 3.
Union of India.
So, first additional government advocate, number 1, 2, 3. 1, 2, 3.
No, my lord. One is a private party, my lord.
Number 3, my lord. I take notice for respondent number
4. Accepts notice.
I may be permitted in addition to serve the learned counsel who appeared for the contested respondent is first respondent, my lord.
So you want to serve the counsel?
In addition, I will serve, my lord.
In addition to normal mode of service, learned advocate to the appellant is permitted to serve. Learned counsel who appeared in the writ proceedings on behalf of respondent 1, 2, and 1 and 2.
1, please. 1 and 2.
1 and 2.
Please.
Commercial appeals, seal number 23. Mr. Siddharth.
My lords, I'm appearing for the appellant, my lords. I'm sorry, my lords, due to some personal inconvenience, I had to travel, my lords. Kindly have it next week, my lords, please.
Wait. Then let it go after 9th of 10th of
Please, my lords, thank you.
10th of January. Yes.
Please.
Number 24. Siddharth.
Commercial appeal, my lord. The appellant, my lord, is the defendant, and the suit was filed by the respondent, saying, my lord, for a recovery of a sum of rupees 40 lakhs plus interest. And the contention of the defendant, my lord, is that the consignments which is mentioned in the plaint is, my lord, the plaintiff would, my lord, place orders on a firm called INR Investments. And INR Investments is a firm who would, my lord, in turn engage various vendors for, my lord, the delivery of the consignments to the various parts of America. And the defendant was one of such vendors whom the INR had invested. And there was absolutely no privity of contract between the plaintiff and the defendant at any point of time. And the fake invoices were produced before the commercial court. And cross-examination was specifically not on the point of not the invoicing. And the witness who appeared before the court, Lord, he would say he joined the company about 14 months prior to Lord, the evidence was led. And these invoices, Lord, pertaining to 2017, when Lord is not even working with the plaintiff company. And Lord, the commercial court has ignored all these aspects. And on that front, and as well as on the commodities which are supplied, they, Lord, at the stretch stay, it's a steel which was supplied. But as well, Lord, the defendant, Lord, has supplied only mangoes and other consumables. So all these aspects, Lord, have been conveniently ignored by the Lord court. And there's an email which is between the defendant as well as INR Investment. I sought for an interim order, Lord. In fact, they abandoned the suit. Halfway, Lord, they abandoned the suit and they go away. The DCF court fee also has not been paid by the plaintiff. That's not abandoned the suit. They abandoned the suit. Lord, it's clear cut, my Lord. After the cross-examination, there's some communication between the counsel as well as the plaintiff. They abandon the suit and go away. They don't even argue the suit. Lord, I have not filed my written arguments and have argued the matter. In spite of which, my Lord, the suit is decreed. Specific observation by the court that the plaintiff, my Lord, does not even address the arguments.
Even the court fee is not paid.
Please, my Lord. Court fee also is not paid. So, my lord, I have not, suddenly if they have not proceed with the execution, file, my lord, the execution, my lord, I will limit.
It is reflected in the judgment that the plaintiff abandoned the suit.
My lord, they have not cross-examined, and in the judgment, my lord, may kindly see in the arguments, my lord, they don't address the arguments. Page number 40, ink page number 40. The first two lines, page paragraph number 24. In this case, the plaintiff remained absent and did not address arguments. The defendants submitted. After the cross-exam, they were supposed to cross-examine my witness. They commenced the cross-examination, my lord. After that, my lord, they abandoned the suit.
Deposit some amount. Lord, it was money decree.
I understand, my lord. Some amount.
Appeal is directed against judgment and decree. This appeal by the original defendant is directed against judgment and decree dated 26th February 2024, passed by learned 87th Additional City Civil Judge, Bengaluru, whereby the appellant defendant are held liable to pay to the plaintiff sum of 40,96,551 along with interest at 24% till the date of realization calculated from 13/7/21. Assailing the impugned judgment and decree from a learned advocate, Mr. So, your senior advocate?
Please, no,
learned advocate, Mr. So and so and so. Inter-alia highlighted the aspect recorded in paragraph 23 and 24 of judgment that the plaintiff examined its authorized signatory. Thereafter, the defendant examined their witnesses, D1. It is then recorded by the case in this case the plaintiff remained absent and did not address the argument. It was submitted that the plaintiff virtually left from the contest of the suit.
Please.
Paragraph notice returnable on 20 February. Learned advocate for the appellant would pray for stay of operation and implementation of the judgment and decree. Since decree is money decree, in all normal circumstances, the stay could be granted only upon condition of deposit of the declared amount. However, noticing the aforesaid peculiar aspect that the plaintiff is stated to have given its argument and did not address the argument, there shall be stay of, and consequently the decree is passed by the court below. There shall be stay of judgment and decree, impugned judgment and decree, on condition that the appellant deposits 15 lakhs.
Will be 10 lakhs, my lord. Again, we pursued, my lord, for 10 lakhs, please.
Then
already court fee also, my lord, has been paid.
So 10 lakhs with proportionate cost and interest.
Please.
10 lakhs with proportionate cost and interest. 10 lakhs with proportionate cost and interest. Within 6 weeks from today.
The LCR may kindly be secured. But the LCR could be not secured. The LCR, the lower court record, the trial court records.
It normally comes once the
unless it is called for, my lord.
there it comes automatically once. The record and proceedings shall be called for from the court concerned so as to read this court before the next date.
Please, oblige.
This is number 25, the Dalwai Venkatesh.
Somebody wanted time here?
Last time, my lord, sir.
You
he
wanted
took
time?
My lord, he has now filed an application for arrest warrant. My lord,
It's not
conditional,
arrest warrant, it's for the attachment of movables, my lord.
my lord, conditional interim order, my lord, I am requesting. Last time it was heard. This is defendant's appeal. My lord, I
You
am
are
not
seeking
opposed.
time or you want to proceed?
So today I fixed some time.
Seeking time. Then don't precipitate thing.
Let that be, my lord's, lordship may kindly consider. Next date, till next date, let him not
No, I'm
precipitate.
ready to argue. No, let the stay order maybe proceeded.
To be proceeded.
Yeah, please.
What is it about? Let that.
My lord, this is defendant's appeal. It's defendant's appeal. My lord, the learned commercial court has decreed against me, my lord. Your lordship would kindly turn to page 18.
Money decree. What is
Yes,
it?
money decree. My lord, the money decree is for the amount of, not so,
1 crore.
1 crore 48 lakhs. The issue, my lords, which I tried to canvass in the last occasion before your lordship says, that my lord, the supply order is between 6/4/2013 to 24/11/2015. Thereafter, my lords, last time, if your lordship kindly recollect, I have passed on a copy of the sale deed, my lords, for consideration, dated 4/11/2016. In which, my lords, I have transferred a property in his name and a positive statement is made saying that the entire amount are settled. My lords, page 5 of the sale deed, my lords, for kindly request your lordships to. My lords, page 5 of the sale deed, my lords. Last time I passed on, it is a part of exhibited document. May I just pass?
Yes. What is this?
My lord, after this suit claim, my lords, your lordship may kindly consider from 2013 to 2015, suit claim. My lord, this is on 4/11, my lord, this is executed. Page 5, my lords, your lordship. The buyer has adjusted on the left-hand side, my lords, your lordship. Page 5 of the sale deed.
Page 5.
Page 5 of the sale deed, your lordships.
Yes.
The buyer has adjusted entire sale consideration of 49,60,000 by way of a settlement of the claim to the buyer in respect of the material supplied.
Your buyer.
My lords, I am the buyer. He is a supplier. Well, I transfer the sale property in his.
He is the buyer.
He is the supplier.
The buyer of the property.
He is the buyer.
Yes.
Yes.
Under the sale deed. In respect of the material supplied to and the receipt of total consideration of 49,60,000. The seller hereby acknowledges, confirm that towards the entire sale consideration as mentioned in full and final settlement of the sale transaction and confirm that there are no amount due outstanding from the buyer to seller on behalf of the seller hereby conveys and so on. My lord, the transaction which were there between the plaintiff and the defendant stood satisfied as on 4/11/2016. Now, this is part of the exhibit. Now, his suit claim, my lords, your lordship would kindly turn to page 18, which the learned judge would have, I guess, extracted, is between 6/4/2013 to 24/11/2015. My lord, internal page 3 of the judgment, in page 18. Notes on the bottom. As per the purchase orders, the supply of iron and steel, plaintiff has supplied the same from 6/4/2013 to 24/11/2015, totally amounting to 9 crores 90 lakhs 81,000 so and so. Out of the said purchases, defendant had retained the material of so and so. Towards the repayment of the balance consideration on 4/11/2016, defendant number 2 has executed a sale in favor of plaintiff towards the immovable property bearing so and so. Now, this was a suit claim. Now, the learned judge would say that there are subsequent transactions for which no suit is filed.
It's not.
So this 49,000 is to the
49 lakhs is settled.
To the satisfaction of entire claim.
Yes. This was the sale deed which I executed and the suit claim is from 13 to 15.
This is sale deed.
Yes. Registered sale deed, my lord, conveying the property.
And these claims which are claiming amount are not subject matter of.
No. That is my humble, which has been overlooked by the learned trial court.
That's kindly exhibit P1 to P4. P1 is the memorandum of understanding dated before the sale, before date of November, 3rd November 2016.
We'll hear it finally. Let the record be called.
My lord, let him not prospect, my lord. The bailiff is coming and creating a problem with the,
80 lakh is due, my lord. There is a money decree.
any date your lordship may
Not
fix will.
produced except the sale date, no other document is produced. This is the money decree and moreover 138 proceedings also initiated.
I am ready with it. Within 2 weeks, will go on with the matter. Let him not, bailiff is coming, my lords, he is creating a.
Moreover, transfer the entire assets, so his son name and some fictitious person's name. Yeah, there is
Solve.
no assets available for execution. Yes, doing this kind of, he is also present before the Contempt court.
Outstanding is 1 crore 37.
That's what the finding of the learned trial judge. Learned trial judge has said, my lords, 1 crore 87 lakh 76,000 is a decretal amount.
Also admitted
With-
the signature found in the exhibit P1. It is-
My lord, either my,
Decretal amount is 1 crore 48 lakhs.
my lord, page 56.
Then,
my lords. With interest, my lords, that has come to 1 crore.
even if you go by your version, then 1 crore 37 lakhs minus 49.
My lords, the decretal amount is, my lords, 87 lakh 76,000 is a decretal amount is.
Principal amount, that is the principal amount.
My lord, either my friend should argue or he should allow me to make, at least clarify the facts. Page 56, my lords, 87 crore 76 lakhs with 12% interest has been awarded by the learned judge. That comes to 148. So, my lords, your lordship may kindly consider, my lord, some reasonable deposit. Within 2 weeks, we'll go on with the matter. There is no difficulty. I'll ready with the matter also. I'll file paper books, my lord, so that.
So decrease for what amount?
86,
1 crore 48.
87.
It is page number.
My lord, my
Let us see.
Not let him not, page 56, my lords, 87 lakhs is a principal amount. With 12%, it comes to 1 crore 48 lakhs. Lordship may kindly turn to page 56.
So 87 lakhs on with 12%
Principal, yes.
comes to 140.
148. The principal amount is 87 lakhs.
Deposit 1/3 of 148.
Lords,
This is money decree normally.
I follow, my lords, what.
We are
what's
not,
in the lordships.
we are not directing the withdrawal or payment.
My lords, may I request for one indulgence, my lords. 3 months time, my lords. For that at least, your lordship may.
10 weeks will give, 10 weeks.
Wait,
10 weeks.
I vote.
We can give, no difficulty. Third learned advocate, Mr. Your Venkatesh
Dalwai.
Dalwai, for the appellant and learned advocate, Mr. Sohan, the respondent who appears on caveat.
Caveat, that's fine.
Caveat.
Yes.
On caveat. The present appeal arises out of judgment and decree dated 13th March 2024, passed by learned 89th Additional City Civil Judge, Bengaluru, in commercial original suit number 906 of 2021. Post of thereby the suit of the plaintiff respondent herein came to be decreed. Post of the appellant, defendants were held liable jointly and severally to pay rupees 1 crore 848 lakhs along with interest at 12% on 87,76,384.51. Full stop. In other words, decree is passed against the appellant's defendants for amount of rupees 1,48,000,000. The dues claimed by the plaintiff were in respect of the purchase orders for supply of iron and steel, which the plaintiff claimed to have supplied between 6/4/13 to 24/11/15 for the total amount of rupees 9,90,81,909. Full stop. While assailing the impugned judgment and decree, from a learned advocate for the appellant would invite attention of the court to the following observation and finding of learned of the court below. in paragraph 2 of the judgment, extracting from paragraph 2 of the judgment. So it starts from page 18. Out of the said purchases, the defendant wants like till due till date. In other words, it was submitted by learned advocate the appellant that sale consideration of rupees 49,60,000 has already been paid.
Yes.
To the defendant.
Transfer of.
Which is not taken into account by learned single judge, and that the said amount ought to have been adjusted in the claim put forward by the plaintiff in the suit instituted by him. Paragraph. When the said aspect was when learned advocate for the respondent, as plaintiff, was confronted with the said aspect and the observation of the court below, he was at his receiving end. Full stop. Appeal paragraph deserves to be admitted. It is accordingly admitted. It shall be posted for final hearing on 14th March. On 17th March 2025. There shall be stay of judgment and decree impugned in the appeal, on condition, however, that in the Fictitious circumstance case, the appellant deposits rupees 50 lakhs with the registry of this court within 10 weeks from today.
Also, it has been already reflected. It has been adjusted in page number 28 of 49,50,000.
Don't say receiving and submitted that the state aspect is already taken note of by a single judge. So the issue requires to be gone into at the final hearing stage.
Great.
Again, your case is that the other claim is.
Yes. Well, subsequently, there were no transactions.
It is the case of the appellant that the rest of the amount decreed by the court does not pertain to the huge purchase order, but they relate to the
different transactions.
Subsequent transactions.
Great.
Record and proceedings shall be called for from the court concerned so as to read this court before the next date of hearing.
This year. 26 urgent.
Yeah.
Number 27.
I appear
Vasant Kumar.
complainant in this case. Lord, basis for the complaint, my lord, pertains to my lord. Kindly see page 8. She, my lord, my advocate has filed counter affidavit, my lords. Page 8 of the papers, my lord, filed by her itself is the basis. First writ petition was filed, my lord, because background is very important, my lord. Counter filed by her, lord, on 23rd of November.
But appeal is pending.
Please, my lord.
Appeal is pending before Supreme Court.
No,
No, it's not.
appeal.
What is this order?
This earlier order which was passed, my lord, this led to the earlier, therefore I wanted to give introduction, my lord, to the.
It's an interim order on which they have filed the
Very well,
contempt.
very well. But first this order was passed by submission. Page 9, my lord, page 9, first para itself, my lord. Petitioner is before this court, calling in question the order passed by Deputy Conservator of Forest on 27/9/2008, whereby he has called in question upon the petitioner to quit and deliver vacant possession of 6 acres of land in Swansana on the premises that petitioner had enclosed this land, which was a forest land. My lord, it was granted like according to the petition. Then, my lords, relevant page 11, my lords, I'll come. Relevant page 11. Government advocate is opposed. Page 11.
Where is that page 11?
Page 11, my lord.
Page 11.
Internal page 4, my lord, of the orders. Para 6. Objection statement which was filed. Page 11, my lords, para 6. The learned advocate, government advocate has produced a copy of notification dated 26th of July 1910. This notification states that there was an earlier notification dated 22nd of December 1900, indicating the boundaries of Srinivasapura Forest, and by the said notification dated so and so, revised boundaries Srinivasapura State Forest were notified. Notification of 1900 states that the land measuring approximately 4,060 acres is situated in Srinivasapura Taluk of Kolar district, while the notification dated 1910 also gives the revised boundaries of approximately 406 acres of Srinivasapura so and so. Notification also contains the boundaries of extent of 406 acres. The notification does not state that survey number, that 87 acres of 406 acres was situated so and so. Authorities who have passed the impugned orders have proceeded on the premise that it was not in dispute that survey 91 is a forest land. Further is very important. Reading of the objections raised by the petitioner indicates that petitioner all along contended that it was a revenue land which was granted to him on 2 occasions, and therefore it would be improper to contend that land in question is a forest land. In view of the fact that there are orders of grant passed in favor of the petitioner, his assertion that lands in question are not forest lands cannot be ignored. The state merely states that the notification of the year 1910 gives a revised boundary for the total extent of 406 acres. Authorities also do not indicate that in which survey numbers these 406 acres of land are situated. Lord, next narration is there. Then next is para 13 is important. Para 13. Authorities cannot unilaterally assume that the petitioner has accepted that his land is situated within the forest area. In fact, map of Srinivasapura Forest, which is produced, indicates that there have been encroachments on several extents of land over the several survey numbers, and thus, unless the basic question as to which survey numbers are in the area of 406 acres are comprised in, it would be improper for Forest Department to unilaterally assume that its land has been encroached upon. In that view of the matter, impugned orders are set aside. Now, very last part is very important. However, liberty is reserved to the Forest Department to conduct a survey to demarcate the approximate area of 406 acres, which was notified as Srinivasapura Forest under notification dated 28th of July 2010. If on such a survey if it is found that there have been encroachments, it would be open to the Forest Department to initiate appropriate action against the encroachers. Needless to state that survey, if any, to be conducted shall be done after notifying. So this was the final order. This, my lord, because, my lord, they did not follow this, my lord, another writ was filed. In the contempt petition, now the next order comes, my lord. Page 18, in the contempt petition. Kindly see, my lord, contempt petition filed by us, my lord.
Earlier contempt.
No. Present contempt. What I read is her objections. Now contempt petition, kindly see. Main contempt petition. Contempt petition. Page 18 is the next order.
The interim order.
It's an interim order.
So that is the contempt is eligible.
In respect of which, page 18, because the continuation, my submission is the continuation is my submission. Page 18, my lord gets that, my lord. This is dated 11th of September 2023. Learned additional government directed to take notice for all the respondents. Learned counsel petitioner directed to serve a copy of the writ petition along with so and so. Learned senior so and so appearing for the petitioner submits that earlier the writ petitioner was before this court in W, which I read just now, complaining that the the Deputy Conservator of Forest Kolar has passed the orders eviction against the petitioner, although land was granted by the revenue authorities. This court, by the order dated 17/4/2023, set aside the order, impugned order therein, and reserved the liberty to the forest officials to conduct a survey to demarcate approximately 406 acres, which were notified as Srinivasapura Forest Taluk under notification dated 28th of July 2010. And if it is found that petitioner is encroached upon any part of the reserved forest, action can be taken. However, survey was required to be conducted in the presence of the parties while giving opportunity of hearing. Learned senior counsel submits that without passing any order, without even issuing notice to the petitioner, respondent forest authorities have entered upon the land of the petitioners and demolished the structures, destroyed the crops. The authorities have not even given a copy of any order if it has been passed by the competent authority. Learned senior counsel would submit that under circumstances, this court in WP number has gave interim protection to the petitioner therein, directing this point not to disturb the person of the petitioner. Learned counsel prays for similarly. Consequently, very important, respondent authorities, more particularly forest officials, are either directed not to dispose the petitioner, not to disturb the peaceful question, and not to enter upon the land of question till next day. This order, according to us, has been disobeyed. But, my lord, the counter has been filed by the other side stating that, my lord, after notice, my lord, after notice and opportunity, my lord, possession have been taken. They have prepared a measure. My lord, he has signed it. They have done it my lord, forcefully. I have filed a counter. I'll read it and leave it to last. Counter I have filed, my lord, on 2nd of December. 2nd of December. I have filed, my lord, a reply to their, my lord.
So you are today dispossessed? You are dispossessed?
I am dispossessed with all this. Dispossessed, they have created all that. Submission is, even a minister has given a statement produced, my lord. He says, survey has not been completed. They want to, my lord, page 10 of my objections, my lord. Honorable Minister himself records, my lord. Page 10 of my reply filed on 2nd of December.
I haven't received
Honorable
the
Minister
reply.
says,
I haven't received the counter affidavit filed by the complainant,
Counter affidavit to main person,
filed by the complainant herein, to my affidavit.
to your
I haven't received it.
let me complete my arguments. 1 minute, I'll only take. My lord, kindly see, 2nd of December 2024 is a counter filed by me, my lord, in this content petition. 2nd of December. I have already served a copy of it. Copy has been served, otherwise they will not.
So what is your stand?
My lord, in my affidavit,
Before we go to your counter, what is your stand?
my stand, my lord, is seen in para 11, 12 and 13 of my affidavit. Basically, their entire contention is notice has not been given. Before the interim order, the possession was already taken by the officials, is my submission. And this was not put before the learned single judge. It wasn't got to the notice of the learned single judge.
Let me complete.
Possession
Only one
is
submission
taken-
I'll make and leave it last. Only one submission I'll make it.
We'll hear.
Kindly see, my lord.
Let her complete.
Very.
My lord, para 11 of my affidavit,
Yes.
I humbly state that upon joint survey, it was established that the land claimed by the complainant herein of 6 acres in survey number 91 falls in the notified Srinivasapura State Forest, and hence as per the order of the Honorable Court in a writ petition so and so, the land in question was found to be encroached
Which is
by
this
the.
order? Which is this order? 1296? Same,
That is the earlier order. before-
earlier.
Yes, which I have put as annexure, document number 1 at page 8, which was just now read by the learned senior.
It was read by.
Yes. So the land in question was found to be encroached by the complainant, hence the respondent authorities, by virtue of that order, initiated eviction under 64A of the Karnataka Forest Act. Now 64A is a summary proceedings, my lord, of eviction. Accordingly, the complainant was evicted. Now these dates are important, 27/8/2023. And the interim order is got on 11/9/2023. So possession and eviction order under section 64A of the Karnataka Forest Act is done on 27/8/23, my lord. And thereafter the interim order is got. So my lord, my submission is there is no contempt because this possession and eviction was done before the interim order was taken by the complainant herein. And if we look at section 64, my lord, it's a summary proceedings and there is an alternate remedy of appeal also. Instead of going through the appeal process and looking that this is a summary proceedings, the complainant comes before this honorable lodge, this honorable bench
So
saying
appeal-
contempt.
Appeal against? Appeal against what?
64A.
No,
64
against which order?
Against the order of eviction, which we have taken, there is an alternate remedy under 64, 3.
Where is that order of eviction? 27/8/23?
27/8/23, my lord.
Where is that?
That is page 25, document number 5. That was the Mahazar done, according to which 26, my lord. Page 26 of my affidavit.
Mazhar. Panchnama.
This is the Mahazar which is signed by the complainant oath.
So against this appeal will lie.
If I may just read that Mahazar for a moment, my lord. Later, page 26. Later, all of us who were present at the spot checked the forest land which falls within the forest area, survey 91, found that K.M. Nagaraj, son of so-and-so, resident of so-and-so, has encroached in the said survey number. The forest official said that the said forest encroachment is in violation of the Forest Act and rules. To Panchayatdar asked to inspect and see the area in order to take possession of the forest encroached area to their department, for which we agreed. Later, as per the above notification, help of JCB, vehicles, etc., this non-forest plant and trees were cleared in the forest encroached by KM Nagaraja. Then, last line, my lord, the Mahazar started at 6 a.m. and ended at 8 a.m. This Mahazar was read over, heard, and found to be correct. And then it is signed. Now, if I take your lordship to section 64A, Section 64A, my lord, of the Karnataka Forest Act 1963, penalty for unauthorized taking possession of land constituted as reserve forest, district so-and-so, so-and-so, so. Any person unauthorizedly occupying any land in reserve forest, district forest, village forest, protected forest, etc., may without prejudice to any other action that may be taken against him under any other provisions of this act or any other law for the time being in force, be summarily evicted by the forest officer, not below the rank of so-and-so, and any crop, including trees raised in the land or any building or other constructions erected thereon shall, if not removed by him within such time as a forest officer may fix, be liable for forfeiture. Now this, if I take your lordship attention to Proviso 3, any person aggrieved by an order of the forest officer under section 1 may within a period in such manner as may be prescribed appeal to the state government or to such other officer be authorized by the state in this behalf, and the order of the forest officer shall, subject to the decision of such appeal, be filed.
Where is the order?
My lord, my submission is after the Mahazar. Now the order has been challenged in the writ petition, the earlier writ petition. That was set aside, and therefore the order stands, my lord, is my humble submission.
Order of eviction. Where is
Is
that?
the order of eviction.
Against which appeal may lie, because against Mazhar, how can appeal will lie?
No, my humble submission is the
That's what I
first
wanted.
writ.
They have not passed any or served upon me any order. That is all.
The
Another
question-
single judge says, my lord, the honorable court says, serve a copy, and then they do
My
not
lord,
serve any
if
copy.
I just take your lordships to the first writ petition, that is document 1, 17th April 23. There the 64A proceedings was set aside stating that reasonable opportunity and Mahazar and the survey had to be conducted. Therefore, when the survey is conducted and Mahazar is,
1 second, that is earlier petition.
yes, which is at document 1, page 8, it commences. I'm looking at page 9, wherein the order was 27/9/2008. That is the 64A order.
Quashed already.
Where is that order?
That order has been quashed by the High Court, my lord. Impugned orders are quashed.
Order passed by deputy, that is what we want to see, where is that?
My lord, in the learned
Must
single
be
judges,
It must be part of the record of the petition.
Please, my lord, I'm thinking so. I'm thinking so. My only submission is the contempt would not lie. My lord, one. My lord, my only submission is contempt would not lie because the interim order was obtained after the possession and eviction was taken. Now, even if we go into the merits, that is the scope of section
Oh.
64A.
Now, go by date wise. Page
Yes.
14 is the order whereby the Forest Department is permitted to initiate action.
My lord, we'll start with the writ petition order, my lord. That is 17th April 23
17th April 23.
of the writ petition, initial writ petition order.
Yes. So Forest Department
Thereafter, my lord,
was permitted to take action.
please take action in accordance with law, giving them opportunity and hearing. But at that moment of time, 64A was not set aside. It was only directed that we look into whether it falls within the forest area or not. Survey.
Then what happened?
Then, my lord, on 27/7/2023, we pasted on the residence of the complainant photographs of the notice.
1 second. 1 second. 27/7/23.
23.
Yes.
Notice was pasted on the residence of the complainant, and that is document number 3 in my affidavit.
Then what happened?
Then 5/8/2023, as per the order, we have conducted Mahazar.
As per the order dated 17/4.
Yes, my lord. And that is document number 4, which is duly also signed by the complainant. Mahazar is 5/8/23.
5/8/23.
Please, my lord. After the Mahazar, it was found that it is encroached forest land. And hence the eviction and possession was taken on 27/8.
Yes, 20.
27/8, my lord.
27/8. That is the order under contempt? No.
No, no, no. The order under contempt is the interim order dated 11/9/23.
Okay, 27/8/23, what happened?
27/8/23 is possession taken. Taken. After the Mahazar. So, my lord, my humble submission is that under 64A, that notice was not set aside because the entire, if we look into the writ petition order, which challenges and asks for quashing of the order passed under 64A, has not been set aside. It has only been said that the authority should conduct survey and appropriately take action.
What is not set aside?
The 64A,
Where is that order?
that order, if you look into the writ petition order dated 17/4/23,
64A order dated?
27/9/2008. The
27/9?
petitioner, 27/9/2008.
2008.
2008 was the first notice of 64A. That has not been set aside.
That is set aside with
64A notice or order.
Order, because this says quash the order dated,
64A was the order for eviction,
yes, please,
2008.
2008.
that is
The
quashed.
petition is filed under Article so and so praying to quash the order passed by the Deputy Conservator of Forest.
That is set aside.
That
That's
is
quashed-
not set
quashed at
aside.
Page 14, page 14, it is questioned.
Yes, it is set aside, page 14, last line of paragraph 13.
Yes. Therefore, there are no fresh orders, but that is all my. Let us show the entire original recollection.
Okay, even if it is set aside, what difference will make?
My lord, my only
So
submission
it is
is,
set aside and liberty is reserved to the forest department to conduct survey
please,
and demarcate the approximate area of so and so and so. So then,
Initiate a proceedings, they have said, initiation of.
my lord,
after survey to initiate procedure. So you have done it or not?
we have done it, my lord. I will just counter verify. Because after possession is, after eviction, possession is taken, so there would be a order also passed. Let me verify on that. However, having said that, my lord, over here, the interim order is got pursuant to the eviction and the possession. So there would be no contempt that would survive is my humble submission. Because these
So
facts,
when the interim order which is complained of for under contempt, for contempt is passed,
11/7,
7/7/23,
11/9/23, sorry,
7/9/20.
please. And eviction and possession is taken on 27/8,
That you gave the date,
27/8,
that 27/8/23 possession was taken.
yes.
So this is date for.
And these facts were not brought before the honorable single judge, learned single judge. Is my humble submission.
So Mr. Rees, Miss counsel is saying that the possession was taken on 27/8/23 and the interim order was passed on 11/9/20.
Please.
My lord, first order is the continuation, first order, my lord, first order that a lordship, my lord, they must demarcate 4,000 so and so acres. My lord, honorable minister says, my lord, at page 10, I put, I'm sorry, page 10, my lord, so my counter has said, honorable minister has given a statement, my lord, proceedings have not even taken place. Page 10 of my counter, my lord, rejoinder has said, honorable minister, on January 2024 says, let the proceedings be done and people have requested him to complete this, they have not done.
I don't have the benefit of what you have filed, sir. Please, can I see?
Just to see here. Honorable minister gives a statement, my lord, that. And they have got to, some orders they should pass, my lord, and make survey. Where is all, they show, my lord, that I have gone out.
Survey is done, Mahazar is conducted, my lord. Now, the only thing is whether possession was taken prior to the interim order, whether the complainant came clean with bona fides to ever before the learned single judge that these certain, the notice, the Mahazar has taken place.
And they are expected to, my lord, after the first initiate the proceedings, pass an order, then, my lord, they short circuit everything and will throw me out. Honorable minister has given a statement, my lord, that it has not been done at all. They have not identified those acres. Page 10 of my papers, my lord, I have submitted. Therefore, my lord, if he, my lord, able to establish that some orders are passed, my lord, I may not have any case. My lord, in person, the first order, the honorable court, my lord, specifically said, my lord, it is open to the authorities to initiate appropriate proceedings and pass orders. No orders are passed, they throw me out, my lord. Particularly, nothing is served upon me. They have destroyed my crop, my lord. It is a granted land that can't be overtaken. Grant lands, and my lord, forest department officer will also be, my lord, party to that, my lord, the committee which grants the land. Forest officer is also, my lord, member of the committee, my lord.
Whether contempt will lie, my lord, especially when they have signed the mahazar and possession is taken before the interim order is passed. That's my only submission. And these facts were not brought before the learned single judge, because the learned single judge, in fact, 64, my lord, is a summary proceeding.
But there should be an order at least. Wasn't an order.
If you look into the provision of 64, made without prejudice to any other action that may be taken against him under any other provision of this act or any other law for the time being in force, be summarily evicted by the forest officer not below the rank of so-and-so, and any crop including trees raised in the land and any building or any other construction erected thereon shall, if not removed by him within such time, the forest officer may fix, be liable for forfeiture, provided that before evicting, he shall be given a reasonable opportunity of being heard. Now, reasonable opportunity, my lord, after mahazar has been done, if we look into the dates, after 1 month, possession has been taken. And if any person aggrieved by any order of the forest officer under this section of having been evicted or possession being taken within a period, appeal against such order to the state government or such other officer as may be authorized by the state government. So it's a summary eviction.
Only one thing I wanted to say, my lord. While issuing notice, my lord, this honorable court very much particularly asked regarding interim. Then, my lord, interim order has to be read along with the main, because in the interim order, earlier order has come, my lord. My lord, their lordship, my lord, your lordships have issued notice only after satisfying that, my lord. Second order, my lord, falls in line with the first, my lord. First is not at all completed with them, my lord. They throw me out, my lord, without demarcating even. Yes, that is read in the interim order passed, my lord, in the latest order. Earlier order is taken into consideration. It's not as if one line order, my lord. Issue notice, interim order is not the order, my lord. Page 18 and 19 of the, my lord, contempt petition, page 18 and 19. My lord, it goes into, runs into pages, my lord, saying what the earlier, my lord, has been done by the.
So in the interim order, if we look into the interim order at page 19, my lord, the learned senior counsel submits that without passing any order, without even issuing notice to the petitioner, the respondent forest authorities have entered upon the lands. Notice has been given. I have put in my affidavit as to how notice was not taken by the complainant, and therefore it was pasted on his residential premises. Document number 2, my lord.
My lord, let me sum up, my lord. I will not, my lord, waste the time of the court, my lord. Para 14 again I'll read and leave it to us.
Document number 3, sorry.
Para 14, I'm sorry, I'm, my lord, straining your lordship, my lord. Para 14 of the first order, very, very meticulously, my lord, ordered. I will read para 14 of the earlier order, para, my lord, page 14, earlier order. Para 14, however, liberty is reserved to the forest department to conduct a survey to demarcate approximate area of 406 acres, which was notified as Srinivas Forest area under notification dated so and so, that is my lord 2010. If on such survey it is found that there have been encroachments, it would be open to the forest department to initiate appropriate proceedings against the encroachers. Where do they initiate? Where you should not go, I hold inquiry and remove me. They can't say, no, you should go, come out. Where do they show? Where do they locate? Honorable learned judge of this honorable court says, demarcate them, find out that they are real encroachers, give them notice, make inquiries, and say, it's easy to say, I have given you a letter, pasted and sent out. Where is Mullah? Honorable Minister, Mullah, if I am not...
Please, it's signed by the complainant also.
Mullah, page 10 of my papers, if I'm sorry, Mullah, I'm extremely sorry. 2nd of December 2024, I have produced a document. An Honorable Minister for the very same subject, Mullah, for forest and ecology environment, Mullah, on 2nd of January 2024, recently. Mullah, page 10 of my objections. I have filed it on 2nd of December 2024. My counter, Mullah. Yes, Mullah. Page 10, Mullah. May I read, Mullah? Page 10. Honorable Minister, Forest and Ecology Department. Your Lordship gets that, Mullah? While enclosing here with the joint representation submitted to the persons from Pattapalli village, Srinaspura Taluk, Kolar district, it noted that eviction of unauthorized occupants by the forest department appears to be in progress. But it is brought to our notice that joint survey has not yet taken place in the Pattapalli village and other adjacent villages. The villagers have requested for not evicting them till the joint survey is conducted by the authorities. Having perused the same, now revenue authorities in the forest department are instructed to conduct joint survey and submit report about the progress. The minister himself said, please do it at the earliest if they are helpful. In January, recently, they say about earlier, June, July.
My lord, for
Therefore, everything, only request you, Lordship, kindly look up to originals and pass orders, my lord.
My lord, Mahazar at page...
Any date convenient, my lord, originals can be seen and orders can be passed.
Mahazar at page 25. Mahazar at page 25, my lord, for a moment. My lord, just for a moment, Mahazar, for a moment, at page 25, it reads as such. The survey and demarcation of survey number 91 of so-and-so village dated 5/8/23 on behalf of Working Plan Survey, Mysore, in the presence of the petitioner, that is the complainant, and it was found that Shri K.M. Nagaraj, son of so-and-so, encroached land falls within the forest area notified as Srinivaspura State Forest. So it was in the presence of the complainant here. It has been noted and detailed in the Mahazar with the signature of the complainant. So now saying that Mahazar has not been conducted, survey has not been conducted without his being aware of the same would not be correct.
We'll take column 13, either for reserve or for orders.
Please, my lord.
Let us have a second. 13th, we are keeping it on 13th. 13th of this.
Much obliged.
13th of this month. Great.
Your court officer? Means submission, my lord. Serial number 8080 kindly have it done. Yeah, after 2 weeks, my lord. I have to take the steps, my lord. Serial number 8080.
Number 18.
88, my lord. 88, my lord.
88.
My senior is engaged in some other court. I have to take steps. We will take steps at office, my lord, please.
20th February.
Yes, my lord.
Can extend out to 20th February as requested by learned advocate for the complaint.
Obliged, my lord.
Tomorrow, my lord, this is a Section 9 petition. It was filed in Mysore Commercial Court. Section 9 petition, my lord, the interim order was refused. Only notice has been issued by the court. The respondents might invoke the bank guarantee. This is a railway contract where the contract has lapsed. It was 2 years ago. In May 2024, it was lapsed. Now they are going to terminate the contract and they are invoking the bank guarantee, my lord. Therefore, there is extreme urgency, my lord.
Bank guarantee is valid up to what?
My lord, this is up to 2025, March 2025, it is valid. No, bank guarantee is valid, but they are going to invoke, my lord. That is the problem. That is the difficulty.
Contract is terminated.
My lord, they were terminated on 25th of November. I was before the court on 26th, my lord. Court has
9th of
Section 9 petition.
9th of Monday.
Next. My lord, tomorrow, my lord, there is extreme urgency, my lord.
9th will give for
Serial number 92, my lord. Some urgency, my lord.
the student matter. Will take
My lord, serial number
92.
Yes. My lord, serial number 89, my lords. In the morning, as I had mentioned, that there is a urgency. Compliance matter 89, my lords.
So what is to be done?
My lords, kindly are at the end of the list at least, my lords. At the end of the list at least, because there is a grave urgency. The complainants are hospitalized. There is a order on 18/4 to be, the substantial payment has to be made by the respondent.
So you are the complainant in the contempt proceeding.
Contempt proceedings.
Who is for the appellant?
Appellant is the other party. That is the respondent itself have come for as a.
You inform Mr. The counsel of the appellant.
Yes, my lords, I'll inform now.
Very well, we'll take up. In order, we'll take up now.
Please, my lord.
All matters at 2:30 in all serial number, in seriatim.
Please.
First 2:30 body, sir. First 2:30 boards, then the matters they are mentioned in serial.
My lord, serial number 90, my lord. Serial number 90.
90.
90.
Yes.
A week's time may kindly be granted, my lord. To take the steps.
Then it will go to 13th February, 13th January.
Much obliged.
Send out to 13th January as requested by learned advocate. Next.
The 230 matters. Serial number 118. So for withdrawal.
Petitioner matters. I filed a memo for withdrawal, withdrawing the petition. Compliance has taken place.
118.
Please.
863 of 24, figures on record, memo dated. Six 11/24.
Memo dated 6/11/24.
Stated as under. There are 2 and 3 to be quoted. In view of above, permission to withdraw the contempt petition is granted, dismissed as withdrawn.
Grateful.
119. So Shetty Vignesh.
That is also for withdrawal. Keep it on 10th, 2/3. Memo is there. Memo is then. Figures on record. Memo dated so and so, so and so. Whereby 30th, 7/20. It is stated by the learned of the appellant that physical possession has been returned to the respondents. As for the interim arrangement ordered by learned single judge in the writ petition number 4/24/24, in that view he seeks to withdraw the writ appeal. Accordingly, writ appeal is found to be withdrawn. Accordingly, permission is granted. The writ appeal is dismissed as withdrawn. Yes, next.
Number 120. Shetty Vignesh.
Memo. Figures on record, memo dated 38/10/24, in which it is stated by learned appellant that writ petition number 6188 of 23 has been disposed of by learned single judge on 21/6/24. In that view, the writ appeal is required to be withdrawn as infectious. In view of what is stated in the memo, dismissed, the writ appeal is dismissed as from infectious. As having become. Yes.
Number 121. CH-1, Sunil Kumar.
Before petition.
Number 4.
Lord, the petitioner, my lord, has submitted a representation to the Election Commission. Very short point for lordship's consideration. He has stated that, my lord, that the respondent number 4, while filing his nomination for the elections to the Gram Panchayat, my lord, he has filed a false affidavit. Now, the Election Commission has revised its stand because as far as keeping his seat is vacant, my lord, he is no longer in tenure. That's one submission, honest submission. Second, my lord, as far as 125A of the Representation of People Act, my lord, any filing of false affidavit, my lord, Election Commission can take action. I only read one paragraph for lordship's kind consideration. I request lordship to kindly take page 60, my lord, of the circular and the press note issued by the Election Commission. Page 60, my lord. Small paragraph, I'll just read. 60. 60, please.
But what you are calling in question?
No, to take action against the false respondent as far as the for filing the false affidavit based on the stand taken by Election Commission. Page 60 is the circular as well as the press note issued by the Election Commission. In that, the relevant portion, page 62, my lord. Only one paragraph I'll read. Page 62, Commission. It starts with this. It says, my lord, the Commission has been receiving complaints regarding furnishing false information in the affidavits of some candidates. As per the exact provision, individuals are filing such complaints in the competent court.
It's 60.
62, my lord. 60.
62.
And relevant portion is at 62, my lord. Sorry. It begins with the line commission has been.
That is also the impugned one. That is also same at page 19. Is same or not? No, it is not same. Same thing is there. All right. Page 62.
Please, my lord. Commission, I'll read only the small paragraph. Lordship's consideration. So it says, the Commission has been receiving complaints regarding furnishing of false information in the affidavits of some candidates. As per the exact provision, individuals are filing such complaints in the competent court under Section 125A of the Representation of People Act, 1951. Now the Commission has reviewed this position and decided that in pursuit of a level playing field, it will take cognizance of complaints which indicate serious omission on the part of the candidate and refer such matters to the relevant investigating authorities on a case-to-case basis. Now, my lord, as on the date of the filing nomination, he himself accepts that there was a criminal case pending against him. In objections, he accepts that.
What do you say?
But I have filed my statement of objections. But what was pending was a case with respect to dishonor of a check. But before even, my lord, the nomination is being filed, but there was a settlement between the parties. And, my lord, in view of the existence of the COVID pandemic, my lord, the relevant settlement memo was unable to be filed. But immediately after the courts have, my lord, started functioning, but an application or a compromise memo was filed and matter has been withdrawn in view of a settlement. But page 10 is the order sheet, my lord. Before the Lok Adalat, my lord, matter has been settled. It is not an offense, my lord. It is only, my lord, a 138 proceeding. It is virtually, my lord, a quasi criminal matter.
You are number 4.
I am the respondent number 4.
Lord, I'll only read his objections, para 4, my lord, where he himself accepts.
If you are agreed, you can still institute the proceedings before the competent police or com.
Yes,
Yes.
yes, to, my lord, approach, my lord, in
But
fact, the.
as per the election commission circular, they say, my lord, they will take action. I'm only requesting them to consider their own circular based on the apex court judgment. That's all. my lord. The circular, they themselves accept that we have changed the stand and we will pursue case to case basis. I'm only requesting them that let them stand by their own stand.
My lord,
Page
option is.
62.
My lord, option is under section 15 of the, my lord, Gram Swaraj Act. He has to file an election petition within the prescribed period of time.
But for the criminal
But he
cases,
waited for 2 years. Well, now he has come up with this writ petition. And he is not the person who has contested, my lord, the election.
I'm a voter of the area. my lord.
He did not file any objections for my nomination. He waited for 2 years, more than 2 years. my lord. Now he has come up with this public interest litigation.
No, my lord.
There is
The
no
petition was
public
filed
interest
in
involved in this.
2021. It went before the single judge, then it went before the Dharwad High Court, and then it has come before Lordship. 3 petitions altogether.
I take your lordship to section 15, my lord. Panchayat
Third
Raj.
learned advocate, Mr. So and so for the petitioner, and learned advocate, Mr.
I am for respondent number 4, BJ Mahesh.
And learned for the petitioner, learned additional government advocate, Ms. Srimati Nilo for respondent 1 and 2. 1. Who is for number 2?
For respondent number 3, my lord.
Learned advocate, Mr.
Shrey. Yes. Yes.
Full name,
VH Shreyas, my lord.
PS Ray for number 3. Chief election commissioner.
Yes, yes, my lord.
And you are for?
I am for respondent number 4, my lord, private respondent.
Where is learned advocate, Mr. So and so for private number 4. Petitioner claiming to be a respectable citizen and public spirited person has filed this petition, styling it as a public interest petition. What is thought to be set aside by advancing a prayer is communication dated 4/3/22, issued by respondent number 2, the deputy commissioner, returning officer. Deputy officer, returning officer.
Deputy Commissioner.
Yes, my lord. He is
From returning officer, whereby the petitioner is intimated
and district.
in response to his complaint that if any grievance remains about the filing of nomination by the candidate concerned, the aggrieved person could file a case in the competent court. Petitioner is responded with the said communication stating that the petitioner could file such case before the competent court. The grievance in the petition paragraph is about the nomination filed by the private number 4 who contested the Gram Panchayat election of Dongri Gram Panchayat. Kanakanahalli ward of Uttara Kannada district in the year 2022 when the elections were held on 11/12/2020. It is the case put forward that in the nomination form filed by respondent 4, he was supposed to declare his assessed liabilities as well as details of any criminal proceedings pending against him. it was stated that the criminal case was pending against this candidate respondent 4 in the court of senior civil judge and principal civil magistrate first class Yellapur, which was CC number 181 of 2018. Full stop. Reliance was placed on section 43 small b into bracket regular 4 of the Karnataka Gram Swaraj and Panchayat Raj Act 1993, which to submit that it provides that if a member does not file the declaration within time without reasonable cause for declaration is found to be false, such member candidate shall be deemed to be guilty of misconduct, and the State Election Commission shall, after giving an opportunity of hearing, remove him from the membership and declare the seat vacant. It is on basis of such premise of facts and pleadings, the aforesaid prayers are made. The other limb of the prayer is to consider the representation of the petitioner and direct the third respondent to take direct respondent 3. The Chief Election Commissioner Bangalore to take action against respondent 4. Full stop. In response, full stop. The affidavit in reply is filed by Election Commission is filed?
No, my lord, they have not filed.
Not filed. What is your stand?
My lords, our stand is that they have take alternate remedies, my lord. They have to file an election petition. That's so.
While the contention of the election petition is that it is open for the petitioner to file election petition after the elections are over. Prior respondent 5 has filed reply to state inter-alia that the criminal case which was filed against him was in respect of the bouncing of check and complaint under section 138 of the Negotiable Instrument Act 1888 was lodged, which was CC case number 181 of 2018 before the court concerned. It is stated that negotiations between the parties resulted into settlement. However, due to pandemic, the formal settlement could not be obtained from the court. Formal order on settlement could not be obtained from the court. In the Lok Adalat dated 14/8/20, and the Lok Adalat held on 14/8/21, it was stated, the proceedings have been closed and the settlement is acted upon. It is stated that the proceedings of the CC number 181 of 2018 no more survived. Paragraph. Apart from the above aspect which goes to the root of the case, the challenge to the nomination form or the complaint about the alleged defect therein could hardly be a subject matter of public interest litigation. Full stop. The aggrieved party in such cases has to opt the remedy of filing election petition against the candidate concerned whose nomination may have been accepted and who may have been elected pursuant thereto. Full stop. Essentially, the dispute raised in this petition is an election dispute to be gone into only in accordance with statutory remedy provided in form of election petition. Without expressing anything on merits, this petition is dismissed on the aforesaid ground.
Please.
Publish.
Hundred and 22. Prakash. 122.
Here for the respondent. My lord. On the last occasion, my lord directed me to produce the check which is bounced, which is issued towards arrears of rent, please. Will not permit me. There are few email correspondence also. The contention raised is that they have surrendered possession.
Where is the appellant? Where is the appellant?
So Prakash M.
Check is bounced.
This 1 crore rupee check which was issued is bounced. Now this is section 9 petition
Towards what?
towards arrears of rent, please.
Area, Keep it on 10.
Please.
Osor matters, seal number 4. Seal number 4.
It has been filed.
Four. Yes.
My lord, the direction was to consider the application filed by the complainant, my lord, seeking permission for sale of land under the PTCL Act. The Assistant Commissioner has issued the notice. They have not turned up, my lord. They have appeared in pursuance of the notice, my lord.
This is page 13 is the order.
And therefore an endorsement has been issued. my lord.
Endorsement was issued.
Complied with. Complied with. Order is complied with.
My lord, they have not,
Or
sorry, my lord, they have not appeared before the authority and given the statement, my lord. Therefore, we have given an endorsement saying that in the event they appear before the authority, we will consider their application. The notice was issued, my lord. They have not turned up.
He was not well, my lord, that's on 21/8/23 when was called for. He did not appear, my lord, along with the papers. Permitted. I'll permit it to make I've permitted to make the papers available to the authority, my lord.
you may do it, but there is no contempt.
The submit will consider, my lord.
Submit all the papers, my lord. The lordship permits me to.
Learn a single judge directed Respondent State to decide the application of the petitioner and pass a approved order. Full stop. The contempt is alleged in respect of alleged non-compliance of the above direction. Full stop. In the affidavit reply filed in response to the proceedings of the contempt, filed by the respondent state, it is stated that the petitioner failed to produce the necessary document. Therefore, no decision could be taken.
Please.
Full stop. And an endorsement to that effect is passed, which is produced on record along with the affidavit reply. Full stop. In that view, it could not be said that any willful contempt is committed by any of the respondents in respect of the directions of learned single judge. Full stop. The contempt proceedings are closed. Push. The paragraph at the same are closed. Full stop. Learned advocate for the complainant, Mr. So and so, would submitted at this stage that complainant would approach the
Assistant
competent
Commissioner.
authority respondents and submit necessary documents. He is permitted, if such document is submitted within 10 days from a appropriate decision in accordance with law shall be taken within further period of 4 weeks.
Very well.
So the contempt is disposed of in the aforesaid terms.
Serial number 12. Sri Marthesh GS, party in person.
Serial number 10.
12.
12.
Serial number 12, Mr. Marthesh.
Lord and party in person was not present in the first session. He was again absent in the second call. Stand over to 18th of December in large interest of justice. Next.
Serial number 86.
86, yes.
Number 86, Mr. Neeraj Kumar.
My lord, at the outset, the registry has raised the objection regarding the maintainability of this writ appeal, as it was filed originally under.
You are the appellant.
Yeah, my lord, I'm appellant.
How can you maintain it? Whose appeal is this? Your appeal?
State.
What?
One is state of Karnataka, another is state of Haryana, and third is the private complainant who is filed the FIR, first initially in Bangalore, and then after 6 months in Panipat, Haryana. So the writ petition was filed for quashing of the FIR.
It is dismissed. One is cost. FIR 50 or 21 is cost. In respect of other, it is dismissed.
So one FIR has been, which was registered here in Bangalore in respect of another case which was filed by Haryana police, a fictitious case that we have attacked them in the night when they came without any warrants.
We have not been served with the petition copy, my lord.
My lord, it has already been served.
Yes, that's our full. What?
My lord, I pray for an interim stay on the proceedings in Haryana, because my lord, when last time this my writ petition was dismissed, I had to go all the way to Haryana. So again, I have to go and appear along with myself, my brother, and our parents. We have to go and appear in Haryana. While initial complaint was filed in Bangalore itself, and the full investigation was carried out in Bangalore itself. Despite that, after 6 months, in violation of the all guidelines and regulation, it.
No, not this. I'm saying.
My lord, on maintainability, if my lord will permit me, I want to place memo of citations before this honorable court.
On 27. Not FIR. If the petition is filed under 227, so appeal. it is not under, it is only under the date. They are so. Yes, what do you?
Lord, petition was filed under 482, my lord. In view of the judgment, my lord, then intra-court appeal is not maintainable, my lord.
My lord, this power to exercise extraterritorial jurisdiction is necessarily exercised under Article 226(2) of the Constitution. My lord, it is ultra vires 482. If we say it has been exercised under 482, then its power is beyond the powers of the 482. And I am having this, my lord, this 15 judgments I intend to place along with memo of citation to support my contention. This issue has gone up to Honorable Supreme Court also. And this Honorable Court has also consistently held one of the judgments pertaining to Rajesh Kumar Kamalia judgment. My lord, FIR was registered in Bihar. And this court admitted the appeal when the agreed party came before it. My lord, Naveen Chandra and Majitia versus State of Maharashtra. Honorable Supreme Court of India has clearly clarified that extraterritorial jurisdiction to quash any petition in other state can be exercised only under Article 226(2) of the Constitution. And my lord, Dharwad bench of this honorable court has also stated that where the powers are exercised by honorable judge under 226 of the Constitution, even though Section 482 CRPC is invoked, the writ appeal will lie before this court.
You got the papers?
No, my lord, I have not been.
Supply copy, then
My
we'll.
lord, already supplied. My lord, I am personally driven. You see, this seal is there. Seal is also there.
13% to supply fresh copy of the entire.
My lord,
set.
already provided, my lord. The seal is there. Their seal.
Then again, supply, it is not the thing. Fresh copy of the set of the entire set of the petition to learn and additional government advocate, Mr. Harish.
My lord, kindly interim stay will be granted. Otherwise, I will have to go.
Without hearing, this is not maintainable as. We'll examine yet your.
My lord, this is the memo of citation is there. It is consistently held that it is maintainable.
Put up on 13th January. Supply copy, then we'll hear.
My lord, this memo of citation I can place before bench or the same day.
You can place.
Not 2 copies.
By 89.
Please, my lords.
Where is the appellant?
My lords, they are not coming, my lords. My lords, the appeal is not admitted. The condonation of delay also has not happened. The basic contention that they have taken is they have not been given opportunity to be heard. But the execution proceedings and the other proceedings before the RERA, my lords, this is a conflict between the builder and the buyer. We are home buyers, my lords. This court, by the order dated 18/4, had asked the respondent to pay a sum of 4 crore rupees, and they have also supplied a affidavit at 89.1 millions, stating that they are going to pay back all the amount which is due. But as of today, they have not come up with any payments, and multiple contempts are before this honorable court, and multiple writ petitions are also filed. And to say that the accused respondent is the top defaulter in the state of Karnataka, my lords. They are not developing the property. They have lost all the licenses. Now they are not ready to pay. Whereas my complainants are suffering with the deteriorating health. And this court has observed that previously also and had ordered them to pay a sum of so and so on 18/4/2024, my lords. Respondent number 4 and 5 have been directed to implement these RERA orders. They are the DC and SR. They are time and time again, they have said that they are going to submit the status report, the affidavit before this court, but they have never done so. They are not intending to implement these RERA orders, execution orders, my lords. The last thing what they did was they have issued a Japti notice. They've also filed a notice on 14/3/2024, that is at annexure A of one of my interim applications. My lords, I have filed interim applications to keep the DC and Tahsildar present because they are not implementing these RERA orders. And I have also filed another application because of the violation made by the accused developer, respondent number 6. He is not paying. He has placed the affidavit before this honorable court. That affidavit has been recorded. And now they have lapsed this affidavit also. They have lapsed this honorable court's order also. They have no regards, my lords, for this honorable court's order or the execution orders that are passed. Only in this 89.1, they owe to the tune of
The
12 crores.
urgency in this.
My lords?
What is the urgency to take up at 2/3?
My lords, the affidavit is lapsed. This court, my lords, the
Is the urgency?
urgency is my complainants are hospitalized, my lords. I have already placed that in one of my interim applications.
That is no urgency to.
It's listed for today, my lords. It's just that,
At 2:30 out of turn.
my lords,
What
I
is the
requested, I said at the end of the list, but the court officer called us now.
No, why end of the list? Whenever it reaches.
Yes, my lord said end of the,
Don't find fault with the court officer.
no, no, my lords.
We are finding fault with us, that why we should take up a matter which is not urgent.
My lords, the complainants are suffering.
There
Their
is no
old
ground,
age, my lords. That's
There
the
is no
reason.
ground to take out of turn. Who is for the appellant?
My lords, I appear for accused number 2, accused number 5, my lord.
Who is the appellant? Whose appeal is, appeal is filed by whom? Who appears for the appellant? This
Mr. Sarvana,
Ozone Urbana Infra Developer.
Sarvana is. One Mr. Sarvana is would appear.
Yes, Sarvana?
Wait, let him come.
Please, my lords.
Don't pass the buck on any of the officer of the court
Please, my lords. No, I'm
in your argument.
no, please, my
That
lords.
is not permissible, not allowed, not tolerable.
Please, my lords.
You have no right
That
to
was not
pass
me.
any fault buck,
No, my lord,
any of the court officers,
that was not the intention.
any of the staff.
No, that was not the intention, my lords.
You are not the authority to comment upon the act of any officer, court officer.
No, that was not the intention, my lords.
Please bear in
Deeply
mind.
obliged, deeply. Please.
Don't put anybody from the office, from the registry in dock for your purpose.
No, my lords. Please. deeply
Our
obliged.
staff is there, it is efficient staff.
Please,
Yes.
deeply obliged.
Still number
You
92?
are too young to indulge into all these things, Mr. Counsel.
No, my lords. Deeply obliged.
Abhishek Malipatil, 92?
Yes, 92. What is it about? Student matter?
Yes, Malots. I'm praying for interim prayer for the students to take up the examination, Malots, from tomorrow. Malots, the contention, simple contention, Malots, that I had raised before the learned single judge, Malots. The maximum number of attempts.
It is an interim order.
There was earlier an interim order, Malots, granting the students to make the examination fees, complete the formalities.
No, order under challenge an interim order.
Malots, it is an interim order, Malots, but it is in the nature of a final order. Malots, my all contentions are completed.
That we'll see.
Malots, may I kindly see the order, Malots? By a memo, Malots, I placed the order. There were many petitions, Malots, connected to the writ petitions that I have filed, which had other issues, Malots, but the contentions that I have raised have been answered and Malots, rejected.
So what is the controversy?
My lords, the maximum number of attempts, my lords, to clear the examination being four. My lords, under the 2019 regulations.
2019.
Yes, my lords. Under the 2019 regulations, my lords, there was a maximum number of attempts contemplated under regulation 7.7.
So those regulations were amended in November 19.
Yes, my lords, 2020, they were, my lords, amended in November 2019.
What was the amendment?
My lords, amendment was to the 1997 regulations by adding another chapter, my lords, which were made applicable, my lords, to the students who are admitted from the academic year 2019-20 onwards. So amendment was to an existing regulations of 1997. My lords, that regulation, my lords, clearly stated that there was a limit in the number of attempts. It also, my lords, had put up there was a regulation which said, my lords, there is a provision for award of grace marks under the old regulations as well. My lords, in 2023, new regulations were framed, my lords. 2nd June 2023.
What was the amendment?
Superseding the, my lords, the regulations.
What was the amendment?
My lords, new regulations, my lords. New regulations were framed. Not an amendment to the older regulations, but a new regulation superseding the old regulations.
In 23.
In 2023.
But what was the amendment in November?
November, my lords, are the 2019 regulations, my lords.
All right.
2019 regulations are the amendment regulations, termed as amendment regulations, but they were amendment to 1997 regulations, but we are referring it as 2019 regulations, my lords, for brevity. That was an amendment in 2019. In 2023, a new regulations were framed, my lords, superseding the older regulations. My lords, the new regulations were made applicable prospectively, my lords, for students who are admitted from the academic year 23-24 onwards. Under the regulations, my lords, a new guidelines were notified, my lords, on 12th June 2023. Again, my lords, on 1st August 2023, which were made applicable retrospectively, my lords, to the students of the academic year 2019-20 onwards. They were made retrospectively applicable. The guidelines were made retrospectively applicable, my lords, to the students. My lords, in the current legal position, the new regulations not being applicable to the petitioners and the guidelines being made applicable to the students, there was no provision, my lords, which was in force, which mandated, my lords, or limited the number of attempts to 4. This was the contention, my lords, that was raised. As it stands today, since 2023, there is no provision which makes number of attempts to 4 that is applicable to the students. In light of that, imposition of that number attempts to 4, my lords, in the absence of any regulation, applicable regulations, is, my lords, challenged before the court.
Please repeat.
My lords, 2000.
Number of attempts were reduced.
No, my lords. There was no mention itself, my lords, as to the number of attempts.
So number of attempts were taken out in the new regulations.
Yes, my lords. The new regulations which were made applicable to the students,
So
there was no mention of number of attempts.
You want to be governed by old or new?
My lords, new one.
New one.
The new one which does not put a limit on in the number of attempts. In fact, my lords, in the new regulations, the grace marks also was removed. We had come before the court.
Grace mark and the other issue is not touched by law.
Is not here, my lords. Grace mark is not an issue before your lordships, my lords. It was an issue in an earlier round of writ petition.
The answers and grace bar are not the issue. Only issue is the.
Yes, my lords. In an earlier round of writ petition, my lords, grace marks was an issue where, my lords, these very students came up before the court asking for 2019 regulation itself to be made applicable because there was a provision for grace marks.
So you are in.
That writ petition, my lords.
Today you are in middle of the.
Yes, my lords, course.
Course.
Yes, my lords. They, my lords, in that writ petition, contrary stand, a stand that the 2019 regulations are not applicable to the students was taken by NMC, based on which, my lords, the writ petition was dismissed, where, my lords, grace marks was not awarded to us. Here, my lords, again, a contrary stand is taken by NMC by saying 2019 regulations will be applicable to the students. Despite court having categorically held in a connected writ petition that the 19 regulations are no more in force, 2023 regulations and guidelines are in force, which are applicable to the students.
So what is the reasoning of learner single judge? Now first show the unamended and amended new regulations.
Please, my lords. My lords, regulations, your lordships will find, my lords, the amended, the 19 regulations at Annexure B, Inc. page 76, my lords, of the writ appeal.
Page
my lords, 76, my lords, ink page 76.
76.
Yes, my lords. 4th November 2019.
Correct.
My lords, the following, clause 2, my lords, the following shall be added as 1A to the regulations of graduate medical education regulations 1997. Part 2, my lords, is the one that was inserted. Part 2 containing the following chapter shall be added to regulations on graduate medical education 1997. That shall be the governing regulations with respect to batches admitted in MBBS course from the academic year 2019 and 20 onwards.
So where is the provision about attempt?
Please, my lords, 7.7, very next page 78, ink page 78.
7.7, more than,
No more than 4 attempts shall be allowed for a candidate to pass the first professional examination. Total period for successful completion of the first professional course shall be
you entered the course when?
2000, my lords, there are 3 sets of petitioners, my lords. One is 2019-20, 2020-21, and 21-22, my lords.
But all when entered this 19 regulations are in.
Yes, my lords.
Then where is the new one?
My lords, the new one, my lords, is at Annexure F, ink page 96, my lords.
Page 96.
Yes, my lords. Annexure F, ink page 96. Undergraduate medical education regulations of 2023. Prospectively enacted, my lords. Prospective enactment without, my lords, there being any savings clause. Superseding effect, my lords, under section 61(2), as well as, my lords, according to them also, which your lordships were to see on page 100, annexure G.
Page 100.
Yes, my lords, annexure G.
No, this provision about the 4 attempts is done away with.
No, my lords, in this, it is made applicable, my lords, regulation 21,
Where is that?
ink page 99, my lords.
99. Yes,
Every student admitted in accordance with these regulations.
where is that?
Please, my lords, very first line, my lords. Regulation 21.
Training period, every student.
Yes, my lords. Every student admitted in accordance with these regulations shall undergo training as per the guidelines published under UGMEB, NMC, and displayed on the NMC website from time to time. Provided under no circumstances, students shall be allowed more than 4 attempts for first year. That's all, my lords. It does not say examinations or, my lords, to clear or 4 years, my lords, period. None of those provisions which is there in 7.7 is reflected here.
So it is same.
It is made, my lords, prospectively applicable for students admitted from this date.
But same provision.
But, my lords, the regulations which are applicable to the students are no more in force. 2019 regulations are no more in force. That was the contention raised, my lords. What was being made applicable to us, my lords, is the curriculum retrospectively, my lords, which is in the very next page. The very next page, my lords.
That is all right. This is prospective according to.
Yes, my lords.
We go with you for the time.
Yes, my
Then
lords.
what?
My lords, then, my lords, as it stands today, no regulation which is applicable to us, which mandates, my lords, there is a number of limits. If there is a provision, my lords, saying, okay, this is the provision that is applied to you, putting a number of limit, yes, my lords, I bow down to it. My lords, why I'm saying, my lords, this.
So this should apply to you. Why shouldn't?
My submission is, my lords, students who were admitted prior to 2019 and 20.
So you are seeking benefit of this regulation?
No, my lords, the CBME guidelines. The guidelines, my lords, the very next guidelines.
Which guideline?
Please, my lords, the very next guidelines.
Yes.
This is the notification which is being made applicable to us, not the regulation, my lords. Guidelines, my lords, I'll just read the first one. Consequent upon publication of the Graduate Medical Education Regulations in Gazette of India, June 2023, in supersession of the Graduate Medical Education Regulations 19 as amended. It was superseded, my lords. Fresh guidelines were notified. My lords, in the very next page is the amended guidelines. That is another guidelines that was notified. This was made applicable to us, my lords, Annexure H. Annexure H, my lords, in page 102. If your lordships were to kindly see 103. Hence, it is notified that, well, it's the last paragraph. Hence, it is notified that competency-based medical education curriculum regulations issued by National Medical Commission with reference number has been implemented mutatis mutandis for students admitted to MBBS course since 2019.
Is Annexure G?
Yes, my lords. Annexure, my lords, annexure G. Yes, my lords. Annexure G and G1, my lords. That is
Yeah.
me. In which, my lords, there is no limit. There is no mention of a limit in the number of attempts. These guidelines were made applicable to us, not the regulations. The regulations are prospective. Guidelines being made applicable to us, my lords, in which there is no such limit. This was, my lords, argued, my lords, before learned single judge in another matter. My lords, may I kindly see this order. There, the contention that these students had raised, my lords, is that the 2019 regulations still apply because we were admitted under 2019 regulations, and guidelines cannot be made applicable to us. This was the contention raised. Court has negated that my lords, contention and said guidelines are the only things that are applicable. 19 is not applicable.
Is curricular and attempt to appear in the examination are different things.
My lords, curriculum and education regulations are similar, my lords. Although, my lords, terminology is different. Education regulations will include the curriculum also, my lords. Attempt is under the course.
Number of attempts permitted
Yes, my lords.
and curriculum.
Yes, my lords.
You can't connect it.
No, it's in the that is my lords, that is the reasoning, my lords, the learned single judge has come to, based on an my lords, oral submission by the NMC. Again, my lords, that is also not correct.
You want to read in page 100 and 203 that it doesn't have the embargo for attempt.
Yes, my lords.
That is not, how can we read it?
My lords, kindly see here, my lords. Now this would make it clear, my lords. What was not considered.
So what is the stage today?
My lords,
Today, what is the position?
my lords, that we have to take up the examination which is going on, my lords. One exam, we have already missed one subject. Two more subjects are, my lords, scheduled from
One is left, one is already gone, then what?
we would request, my lords, for that examination to be reconducted at the end of, my lords, the theory exams, which they have also proposed, my lords.
They'll be retest
Conduct the retest, my lords.
of the left out subject.
Yes, my lords. My lords, now, what I wanted to point out, your lordships had this question, curriculum cannot be a number of attempts. Kindly see the new notification issued by National Medical
No,
Commission.
today, according to you, number of attempts, namely 4, applies to you or doesn't?
Does not apply to me.
By virtue of this curriculum.
Yes, my lords. Kindly see the curriculum now, my lords, that they have notified, the new curriculum, my lords, 12/9/2024. Competency-based medical education curriculum, very same curriculum, my lords. A new curriculum is now made notified. This is, my lords, very next page, if your lordships were to see. Very next page, my lords. Last line. These guidelines will supersede the earlier guidelines issued by Undergraduate Medical Education Board and will be implemented from the MBBS batch of 2024-25 onwards. In the new curriculum, if your lordships were to kindly come to, my lords, numbered page 28, bottom numbered page 28. My lords, my apologies, I have not numbered it. My lords, next page, my lords, in the bottom there's 28. My lords, supplementary examination.
Supplementary.
My lords, found that paragraph supplementary examination, my lords, in page number 28.
Supplementary. Where is it? Supplementary.
Yes, my lords. In that, my lords, I'll read the 5th line, my lords. If student fails in supplementary examination in phase 1, the student goes to the junior batch for learning, teaching, learning, as well as for university examination. There shall be no supplementary batches. If a candidate has not appeared for examination, both theory and practical for a subject, then it shall be counted as an attempt for that subject. Partial attendance, only theory or only practical in any subject shall be counted as an attempt. No more than 4 attempts shall be allowed for candidate to pass the phase 1 examination. There is a clear mention of, my lords, a provision under the guidelines itself. This, my lords, is again made applicable from 24-25 onwards by the very notification. In the earlier guidelines, which has been made applicable to me, not carrying a provision, my lords, regarding the number of attempts, there being no provision which is in force.
All logic is not law.
So that is, to that extent, my lords, why I'm requesting for this? My lords, the reason why I'm requesting
You
for
are
this.
good in logic, but that is not the law.
No, my lords, the reason why I'm requesting for this is, my lords, even as of today, the students who are admitted prior to 2019 and 20, my lords, who are called as RS3 batch students, they still get maximum number of attempts. No, there is no limit. Students prior to this 2019 batch still get unlimited number of attempts to clear the examination. Again, my lords, I can show.
What is page 100? It is a circular.
Page 100, my lords.
You are relying on this page 100.
This is a circular only, my lords. Guidelines are by a circular, not a regulation. This is what is made applicable to us. CBME guidelines.
No, you are contending on this way that the four number of attempts will not apply to you.
Yes.
What is the relation with this? How do you connect the number of attempts with this?
Because, my lords, in this guidelines itself, Annexure G and G1, 101, gives the entire course, my lords, how MBBS course has to go, my lords, has to be proceeded with. Basically, my lords, this replaces the 2019 regulations. Whatever was provided under 2019 regulations is provided under these guidelines in this notification, where, my lords, the number of attempts is not there. And they've taken away the provision of grace marks. Court, my lords, categorically, my lords, the judgment that I passed, categorically held, my lords, that these guidelines are applicable to you, regulations are not applicable to you. My lords, I'll just point out to that judgment. A contrary, my lords, argument was raised in this judgment. Order passed, my lords, on 19 September 2024. My lords, may kindly come to page 44, my lords. Paragraph 28. The contention of extending the benefit of awarding grace marks under the 2019 regulations post coming into force of the regulation 2023 and UG-MEB guidelines of 23, the guidelines, my lords, is liable to be rejected in light of the discussion infra.
That is correct.
My lords, that
Here we are confronted with a different situation. Where you are trying to contend that since in the curriculum, there is no mention of attempt.
Yes, my lords.
That limit of 4 attempt doesn't apply.
Yes, yes, my lords. My lords, the regulations are prospective, my lords. Regulations do not say, my lords, that, my lords, whatever, my lords, the NMC wants to make it applicable to a category of students, it has to be by writing. It can't be assumed, my lords, that a rule applies to somebody.
But there is no nexus with this curriculum to the number of attempts.
My lords, curriculum, I just pointed out the new curriculum, which also makes provision for a number of attempts. The new curriculum in 2024 that is now notified prospectively for academic year 24-25. There is a clear mention of number of attempts. My lords, that is why, my lords, there is no intelligible differentiate between.
You are prosecuting which study? First year MBBS?
Yes, my lords.
Or second year?
First year MBBS.
Passed, already passed.
My lords, if may also consider most of these students, my lords, have already paid the entire course fee.
No, you are in which year?
First year, my lords.
And this is, we are dealing with first year exam.
First year MBBS. My lords, pursuant to interim order, which was granted.
Any earlier examination you passed in this year?
Yes, my lords. My lords, in March, when it was conducted, was the last of the examinations attended. They have cleared some subjects. Only one subject is of one of the students is remaining. In fact, my lords, one of the other students had met with an accident on the day of examination.
That is all. How many students here?
13 students.
13 students?
Yes, my lords. 13 students are
It is only one.
13 students are before you.
This is Afita, Afifa.
13 appellants, my lords.
13 kind.
My lords, 30.
Only one petitioner is there.
No, my lords, different petitions were filed. That is a common, my lords, I have filed.
Group of appeals?
Yes, my lords. Group of writ petitions, my lords.
Appeal, how many appeals?
Appeal is 13, my lords, 13 appellants.
So all are seeking to appear in different subjects?
Yes, my lords. One opportunity, if your lordships are to give, my lords, they will go through. Otherwise, my lords, a huge amount of financial burden is on the family as well, my lords. And these are all COVID-19, my lords, affected students. In this technical argument, my lords, were to be accepted, they will get a lease of life. One peculiar circumstances arose, my lords, after the interim order was passed.
You have crossed 4 attempts.
Yes, my lords, yes.
So they want additional, sir.
Yes.
Additional attempt.
Yes.
On the ground that the.
My lords, 3 of the students, my lords, out of the 3 subjects have not attempted one of the subject for 4 attempts, because there is one more rule which says partial attendance in examination will be counted as an attempt. That is also, my lords, because these students were not told if you don't write one of the subjects out of the 2 subjects in an examination, even for that subject, it will be counted as an attempt. They have missed out, my lords, because they were not guided properly. They said they are safeguarding their attempts by wanting to write it later. They have been counted as an attempt even though they have not attempted that exam.
Which is the serial number?
90,
All 13 appeals are
92,
there?
my lords.
13 appeals are listed?
13 appellants, my lords.
13 appellants or appeals?
13 appellants, common appeal I have filed, my lords, but they were different petitioners.
How can you, but that practice is not correct in this cycle.
It is permitted here.
One appeal in respect of different order.
By mentioning different, my lords, numbers, my lords, we have.
You must file a separate appeal. This learner single judge order is common.
Yes, my lords, common order, my lords.
Where is that order? Page?
My lords, it is in the memo that I, yesterday, my lords, it was not released. I have given it yesterday, my lords, by a memo.
This is a threat appeal. Appellants are 13 in numbers. They are the original petitioners in the respective writ petitions mentioned in the course title. They are the students aggrieved. By common order of learned single judge dated 29th November 2024. Since learned single judge in his said order passed during the pendency of the writ petitions came to conclusion that appellant students who are prosecuting their first MBBS course are not entitled to have appear in the examinations in the different subjects of the course beyond 4 attempts, four. All of them have completed 4 attempts to be thereafter rendered ineligible for appearing in further exam, for appearing in examination, for appearing in the further examination, the present appeal is filed. While it is true that the order brought under the appellate jurisdiction is an interim order, and in normal circumstances, the court would not entertain the appeal against the order, which is interim in nature. However, the present order finally debars the students, finally denies the students from appearing in the examination, holding that they are not entitled to have the fifth attempt. Full stop. In that view, the order could be said to have, could be said to have a trapping of finality in respect of the rights of the students to appear in the examination. In that view, the appeal was considered, appeal has been considered on merits. It is contended by learned advocate for the appellant, Mr. So-and-so, so-and-so. But nobody is there, your opposite. Then how ex parte will proceed?
Only for appearance for the moment, my lords. Appearance in the examination, keeping open the question, your lordships. Kindly consider. Because exams are going on. I have moved it very next day, my lords, on Saturday, that 29th order was passed, 30th itself, I moved it.
Trappings of finality, then notice returnable on. When there is exam? Tomorrow?
Yes.
And day after?
My lords, tomorrow up till, my lords, two more subjects are there, my lords.
Notice returnable on 18th of December 2024. Learned advocate for the appellant would press for interim relief, submitting that the examinations in respect of certain subjects are to be held on.
My lords, from 6th, my lords. 6th up till 13th.
From 6th of December, today.
Yes, tomorrow, my lords. Today is 5th, my lords, from tomorrow.
Tomorrow, from 6th of December till 13th of December. And that unless the petitioners are permitted to sit in the examination, an irreversible situation may arise for the petitioners, since the writ petition and the main prayer made by them in the respective writ petitions are at large for consideration on merits by learned single judge. Paragraph. While seeking the interim or while praying for permitting the appellants to appear in the examination, controversy was highlighted. Submitting that in the by submitting that in the regulations on graduate medical education 1997, a provision was there was a condition in regulation 7.7 that no more than 4 attempts shall be allowed for a candidate to pass first professional examination. In other words, in the said regulations of 1997, the number of attempts were limited to 4. Full stop. The said regulations came to be amended in November 2019, and thereafter, in the year 2023, they were repealed. Superseded. New regulations, where are they?
My lords,
Full stop. Superseded, full stop. New regulations
96, my lords, annexure F, ink page 96.
by the National Medical Commission
Yes.
were brought into force by notification dated new regulations called Graduate Medical Education Regulations 2023 into GMER 2020, GMR-23 bracket over, were brought into force by notification dated 2nd June 2023. It was submitted that along with the said substitution of the notification, the educational authorities announced the what curriculum, what do you say, Mr. Curriculum?
Yes, my lords, it's called next page, my lords, competency-based medical education
Where is
curriculum.
that competency based?
My lords, the annexure G1, it's very next page.
Announce
G
the
and G1.
competency. Where is that competency based?
Next page, my lords. The next page, my lords. The last of the nomenclature.
Announce the competency based medical education curriculum.
This is in force, my lords, 1st August.
CBME, bracket or guidelines. Which were made effective from 1/8/2023.
No, my lords, for the academic year 2019-20. Students.
For the academic 2019.
Students admitted to the academic year 2019 and
Understood.
20. These guidelines were made applicable retrospectively for those students.
It is the contention that in these guidelines and the providences thereof, there is no
Yes, my lords. No limit.
contemplation about minimum number of attempts which could be permitted to the students. Full stop. It is contended, therefore, the students should be permitted to take a 5th examination attempt in respect of the said curriculum,
Subjects, my lords.
in respect to said subject
Same subjects. Yes,
in the curriculum.
yes, my lords. But that would, yes, my lords. It's the same curriculum, my lords. Although they've repeated it, it's the same
said
curriculum.
in the subject curriculums.
Yes, my lords.
In the subject in the curriculum, in the subjects of the curriculum,
Yes, my lords.
correct?
Yes, my lords.
Subjects.
Subjects of the phase 1 MBBS course.
Subjects of the, no, we want curriculum.
Yes, my lords. It's the phase 1 is given in the
You will
curriculum.
not fail. We are somehow trying to assist you. So your
Curriculum.
subjects are based on curriculum or
Yes,
not?
yes, my lords. Subjects are based on the curriculum only, my lords, that has been notified.
Subjects which are based on the curriculum,
Yes,
so
ma'am.
notified. In order to paragraph buttress the submission that the notifying the curriculum, efficiency, what is that? Efficiency based, competency based curriculum, comma, the number of attempts were dispensed with, comma, learned advocate pointed out in juxtaposition the subsequent curriculum.
Yes,
Notified, where is that?
my lords, I've handed out over to your lordships, my lords. 2024,
Notified.
12th September 2024.
12 September 2024,
Yes,
in which there is a specific mention about the
yes, my lords.
4 attempts
Yes, my lords.
only to be permitted to the students.
Yes, my lords.
Full stop. It was therefore submitted that in respect of the subjects for which the examination is to be taken on 6th to last till 13th of December, comma, the embargo of 4 attempts would not apply. Full stop. This contention would be examined only at the final hearing stage. However, there is some prima facie value of this contention as far as grant of interim relief is concerned. Full stop. The submission could be countenanced that if the students are not permitted to sit in the ensuing examination, comma, a serious prejudice may be caused to the petitioners and an irreversible situation may obtain for them in the event they succeed in the petition which is pending. Full stop. In that view, and in view that the question of career of the students who are undergoing the medical, first year medical course is concerned, the court is inclined to permit the appellants to sit and take examinations, which is to be held from 6th December to 13th December. Therefore, by way of head interim leave, petitioners shall be permitted to take the examination, which is to take place from 6th December to 12th December, 12th is 13th December.
My lords, 104 is, my lords, the schedule, page number 104. Those two papers, my lords, on 2nd and 4th.
Tell the date from 6th to 13th.
My lords, may kindly direct the university to conduct these two, my lords, at the end of after 13.
Permitting the examination, full stop. The examination are to take place as per the schedule prescribed, the schedule mentioned, which is agenda, and this you just page 104 table, full stop. It appears that the examinations are yet to take place on 6th, 9th, 11th, and 13th, full stop. Therefore, it is provided by of head interim leave that the appellants students shall be permitted to appear in those examinations to be held on 6th, 9th, 11th, and 13th of December. It is clarified that the permission granted to the appellants to appear in the examination by this order, as well as the factum of their appearance in the examination shall not create any right or equity in their favor, and that the result of the examination shall not be declared without the permission of the court. Full stop. The order of learned single judge dated so and so impugned in this appeal is modified to the aforesaid extent. All the appeals are no, only notice.
My lords,
And that they will dispose of all.
my lords, my request, my lords, on the exams that they have missed, that is the anatomy and anatomy 2, that one subject, kindly direct them to conduct it after my lords 13th. Kindly direct the university to conduct that examination for the appellants after the 13th. They have done so, my lords, on the earlier occasion.
You are permitted, that's all, nothing more.
My lords, I missed out, my lords, because of the fact that I did not get.
Permitted, we permitted. They have to permit.
No, my lords, sir, the first two exams, my lords. Your lordships have.
The exam, we are not touching, it is gone. We can't set the clock back. If they take a retest, you come before the court and take the order if it is available.
My lords, retest, my lords.
What do you want now?
Kindly, my lords, direct them to reconduct this examination for these students.
That is too much, going too far. As and when the occasion arises, you come before the court. Or you pray separately.
I'll pray separately, my lords.
That's all.
Please, my lords. Please, my lords, I'll pray separately.
At the line, after table. The two examinations on 2/12/24 and 4/12/24 has already been held. Therefore, at this stage, the question of permitting the petitioners in their students does not arise. At this stage.
Open for the students to
It
make.
is open and at this stage is everything.
But that's the main subject.
There
my
must
lords.
be a limit to a compassionate jurisdiction of the court.
Yes. Deeply obliged, my lords. My lords, I request for hand delivery, my lords, of the.
And delivery.
Great.
Service by hand delivery is permitted today. So type out the order first. Yes.
Deeply obliged, my lords. Great.
Comply the office objections before. Office objections shall be complied with before the next day.
Before the next day. Yes.
Number 115. Indita Hadipur.
Your appellant has come, Mr. Your appellant has come.
Please, my lord.
Yes, what is it about?
My lord, this is an appeal where the learned single judge has struck down, my lord. My lord,
May I make one submission, madam? The petitioner, the appellants who are here before your lordship, they are the implementing agency. And the order passed by the learned single judge quashing the paragraph 83 was notified by Union of India, Government of India. So the Government of India is the aggrieved party, whereas the appellants who are before your lordship are the implementing agency. They cannot be aggrieved by.
I'll deal with that, but in fact, my learned friend had
Therefore,
made that
that
objection.
is
the
first
very
point,
first
my lord.
day.
First point. Second point, the Union of India, I am told the Union of India itself is contemplating to file a writ appeal.
My lord, this is.
So if that is so, then it is
I'm
better
so
to
sorry,
be
my
heard.
lord. Every single attempt has been made to delay this appeal. My lord had expedited the hearing only because I could make out a case and seek some protection.
What is the urgency in this?
My lord, the urgency, may I take a time and moment and explain what the urgency?
The provision is struck down.
Struck down.
The problem is, my lord, this provision protects Provident Fund for all these workers.
It is all right. You may have an important subject matter. But
No, it's not the importance of it. I'm on the urgency of it. I'm on the urgency.
Really
of it.
because the subject is important doesn't book the urgency.
I bow down.
Matter
May I
will
explain
have
what
to be-
the urgency is, my lord? In
Sorry.
respect of all these people, throughout their service, they have contributed their provident fund. That money is with us. We are the trustees of this money. They want.
Who are you? Yes.
I'm the Central Board of Trustees under the EPF Act. The appeal has been filed through the Commissioner. So we are the trustees of this money. Now, all these people means foreigners who are employed in India and Indians who are working abroad. Both these sets of people together constitute international workers as a definition under the scheme. All these people wish to claim their PF. Their claims are lying with us. There are three claims they are making: Provident Fund, their pension, and their life insurance. All these three claims are now piling up. We are required to settle those claims. So in the event my lord wishes to pose this matter for a detailed hearing later, permit me to at least settle those claims, because this money, my lord, either ways, if I succeed, I pay this money to them as PF, life insurance or pension. If I lose, I pay this money as a refund to the same people. So the impact would be all the same either ways. So at least the.
But what is the hurry on your part to pay?
My lord, because it is their money, they want that money.
My lord.
Monies are withdrawn.
Nobody has come before the court.
No.
They are not chosen to come.
It is the trustees who have come before my lord. The trustees are duty bound, because if these people want to, my lord, we have these claims with us. These claims where they want to withdraw their money from their accounts.
My lord.
It is their money and nobody else's. Nobody else's money it is.
My lord, as.
So in the unlikely event I lose the matter, I'll have to refund it to them because this is what they had contributed. If I succeed, I pay to them as PF and pension and insurance. They have claimed that money as PF, pension and insurance. So, my lord, may at least permit me to go ahead and settle the claims. My lord, the problem is there are 30,000 people, 30,000 Indians living abroad. Under the scheme, we permit them to.
Your benevolence is appreciated, but there is no.
My lord,
This seems to be a very lopsided kind of approach. I appear for the first respondent. I am the employer.
You are for Mr. Naganand.
Sorry.
He is for the.
I appear for the employer, not the first respondent.
First respondent.
I was the writ petitioner.
This can wait for.
Yes,
Detailed
certainly.
my lord, the final disposal may wait. I bow down to my lord. Permit me to settle the claims which are
No,
there
no,
with us.
no.
My lord, I'm so sorry, Mr. Naganand, permit me to submit my point. My lord, somebody might be under medical duress, because the reasons why we permit the withdrawal is if somebody wants to withdraw money for their children's marriage, their medical bills, their life insurance, things like that. Now, if we stop settling all these things, that's the first problem. Second problem, my lord. My lord was on an urgency. May I state the second big problem? With the striking down of the paragraph of the legislation, we are in, as a country, we are in material breach of our treaty obligations. This paragraph is made pursuant to 21 international treaties India has entered into. If we are not enforcing these treaty obligations, those countries with whom we have the treaty would cease to extend reciprocal obligations they had undertaken in respect of Indians in those countries. This constitutes material breach under Article 60 of Vienna Convention, my lord. That's the second problem. Third problem, my lord. The same matter, my lord, is pending before two other high courts. Delhi High Court had adjourned the matter, knowing that my lord was hearing this matter. So The other courts are also deferring this so that my lords may hear it. So all I'm saying is only in respect of people who want this money for urgent needs, may I pay, it's their money. They can't have a problem with that. It's not their money.
They are not before the court.
Lord, that is
Well,
not
as
even
trustees,
stated
we
in
have
the
to be
affidavit.
before, we are the trustees. We are the trustees of the money.
My lord.
If the beneficiary wants the money from the trustee,
If somebody comes, we'll see what to do.
my lord, we'll file those claims. We'll file all of those claims. The claims are piling up throughout the country now. We'll file all of those claims.
So we'll hear the appeal. There is no question of not hearing the appeal.
I realize my lord has already issued notice. The pleadings are complete. They have filed their response. Everything is done. Only interim relief, my lord. Permit me to settle the claims because one can only speculate what kind of problems those people might be under.
My lord, such a
If my lord wishes, we'll file those claims also. Every single claim where a person indicates for this urgency, I need the money immediately. I'll place those on record if that is the case, my lord.
My lord, as of date, no such statement is even made in the application in support. There is.
No, we have made that statement, sir. Read the application.
I'm reading up it.
Heard learned advocate Mr. So for the appellant. Learned senior advocate Mr. Nagananda for respondent.
Respondent number 1.
One.
I appear for respondent number 2, my lords.
What is your good name?
Kumar M.N., my lords.
Kumar MM for respondent 2 and learned advocate Mr.
Vasuki, I'll give mine. Vasuki KN.
With Nagananda. So Nagananda with Vasuki KM. While learned advocate for the appellant pressed for interim leave to the effect that the amount may be permitted to be released in favor of the employees.
Yes,
yes.
Full stop. At this stage, when the appeal is pending for final consideration, the court is not inclined from the facts and circumstances case to pass an interim order, more particularly when, while issuing notice on 24/10/24, the appeal was already contemplated to be posted for final hearing.
In fact, what my lord had observed was
in that view, put upon
my lord's convenience. My lord. Whenever my lord has time, we can argue this matter.
February.
My lord, that will be a little too distant. That might be a little too distant, my lord.
Little too.
Could it be 16th December, my lords? Union of India is also filing the appeal. You can take it up together because there are some other issues which is arising under the essays.
30th January.
May be heard in
My lords,
January.
That's a big day.
Little
No, 30th.
advance, my lords. 16th or 17th January at least, my lords. Some.
Yes, next.
Obliged, my lord. So grateful.
Number 28, Sunil Kumar Patel.
Complainant, my lord. 28 to 31, my lords. 28 to 31, all are connected, my lords.
My lord,
28 to
this,
30.
Yes.
Yes.
I pray for some time.
This is regarding the forest land being compensated for the lands acquired of the complainants, my lords.
Which the direction page?
My lord, I request for some time in 28, my lord.
The grant time, but which is the direction which is to be?
Please, my lords.
It is only considered of representation.
Yes, my
At
lords.
the request of learned additional advocate, additional government.
Earlier complaints affidavit was filed by the state. That was rejected by this on.
10 to 20th January, it is expected that before the next date, the directions of learner single judge will be complied.
28, 20,
Up to 31.
Up to 30.
yes, please.
Next.
Much obliged.
This is 32 to Vachan H.
I appear for the
Cover
petitioner's
this one.
merits. On 29/2024, my lords had directed the state government to, if my lord sees the order dated 29/2024 minutes. Certain directions were given to the state. Respondent number 1. Paragraph number 5 minutes.
property was auctioned, my lord, on 5th November 2024. There was a bidder for 4 apartments, my lord. 6 apartments were notified for sale, out of which 4 there was bidders, my lord, for a sum of rupees 4 crore 23 lakhs, my lord.
We had recorded last.
No, my lord, earlier that was notified for
was-
sale, my lord. It was unsuccessful, my lord. There were no bidders earlier. We put the property for sale once again.
You filed some reply?
My reply was filed earlier, my lord, much before that. In June 2024, reply was filed, my lord. Thereafter, there was order for bringing the property for sale. We have now conducted the auction, my lord. Lord, the aggregate amount to be recovered is about 3 crore 67 lakhs. Now the properties have been sold for 4 crore 23 lakhs, my lord.
Race auction was to be conducted on 5/11.
Yes, please, my lord. It was conducted, my lord. There were 6 flats were brought for sale, out of which 4 apartments, my lord, there were bidders. The total value is 4 crores 23 lakhs. The aggregate amount to be recovered is about only 3 crore 67 lakhs. So what is sold, my lord, would take care of the requirement, my lord, here.
My lords.
And now 25% has been deposited with the Tahsildar. Now, subject to the confirmation from Deputy Commissioner, my lord, remaining 75% will be collected and deposited with the RERA authorities, my lord, in due course.
That's once the sale is completed, my lords, I have no grievance, my lords.
My lord, we
Only-
have to
only-
collect the remaining 75% and deposit with the RERA authorities, my lord, then thereafter.
Only one request, let that sale take place, my lords. After that, the matter may be
Very well,
disposed
my
of.
lord. We'll update the court. Now,
Let-
25%
the-
is in deposit, my lord.
Let the sale take place, my lords. After that, I have no grievance. Let this petition be disposed of. Only thing is that month by month, this was monitored by this honorable court. That's the reason it has attained the stage of this, my lords. Once that takes place, I have no grievance. Only thing is, this matter may be called out in January, my lords. By then, the sale will take place.
Yes, what do you want?
My lords, let the sale take place, my lords. After that, the matter may be disposed of.
Still
They're also
70
agreeing for that.
All that, we'll post it on 21st January. But
Please, my
Please,
lord.
my lords.
The remaining
By- by
75%.
By then, they should be
Remaining
able to
75%
deposit the
will
money
require
before.
in the due.
order was passed on 20th 9/24. It is stated that even in the auction, which was scheduled to take place on 5/11/24.
Conducted,
bids-
my lord.
No bids were received.
No, my lord. Earlier, July it was held, my lord, no bid. 5th November, there was bid, my lord. 4 apartments were sold.
There is a bid.
Please, my lord.
There is a bid. Bids were received in 4 apartments.
In respect of 4 apartments for an aggregate value
2 apartments remains to be sold.
unsold, my lord, but this, whatever is sold, my lord, will take care of the amount due. That will satisfy the requirement.
Think, sir.
That will satisfy the requirement.
That will satisfy. Only requirement is this, my lords. Now they only deposited 25%.
25%
The
is in
sale has
deposit,
to
my
be
lord.
taken place. Once the sale is taken place, the money will be deposited in the RERA. Then I don't have any grievance, my lords.
Now 25%
Until
is
then,
in
it may
deposit.
be adjourned.
So again, write down on 20th 9/24, the following order was passed, the court entire order, full stop. As per the order, it was recorded that on 5/11/24, the auction was scheduled, full stop. Today, when the petition came up for consideration, learned additional government advocate Mr. Harish
Please, my lord.
stated that the auction was conducted on 5/11/24, and in the auction, 4 flats, public apartments could be sold off. The bidder
Deposited 25% of
5% amount. The rest of the amount is likely to be realized.
deposited upon
550.
confirmation from the deputy commissioner.
Full stop, stand over to 21st of, we say 8th of January,
Please, my lord.
Please, my lord.
to be listed at 2:30. So nothing will survive on this.
Nothing would survive, my lord. We will deposit the amount with RERA authorities, my lord.
On-
Today also nothing survive.
Well, correct, man. So only why I'm asking for
25% is
My lord, this,
deposited. The-
no, my lord. 25% will amount to 1 crore, my lord.
It is further stated that the balance of the amount will satisfy the,
well, as
Satisfy
that,
the entire dues of the complainants in this
in
case.
that view, nothing survives in the
well,
present.
may I request only,
Disposed of accordingly.
may I make only one submission, my lords. this matter has reached such an extent because the matter was kept pending, my lords, because on the first date of hearing only my lords is directed that there is no violation. Now if this order is my lords, they will not deposit the money. That's the only apprehension. Let it be there only till 21st of January, my lords.
That is not the domain of contempt jurisdiction. If they don't.
Then may I seek this, my lords. Liberty may be granted for me to reopen the
Therefore,
contempt
said
petition.
the directions of learned single are complied with, and it could not be are substantially complied with.
Please.
It could not be said that any willful contempt is committed by any of the respondents. The contempt petition will not survive and dispose of it.
Great for me.
Next.
Number 33, PSP total.
Yes, what is it?
Here for accused number 2, my lords, we have filed a complaints affidavit on 4 November 24, my lords.
Copy has not been served.
My lords, we have filed it on 4 November 2024, my lords.
Where is it?
The direction is to consider as representation.
Correct. Where is that consideration?
My lords, it is in
Page
annexure R5, my lords. Page number,
R2, R2. Where is your endorsement order?
my lords, page number 29, my lords.
29. So it is over, Mr.
No, my lords, my lords, for a moment, my lords, I'll get instructions from the party, my lords. My lords, I was eligible from 2013, my lords, for the post of associate professor. And my lords, in meantime, what happened, my lords, in 2015, I was, went to higher studies, my lords. Since I didn't complete, my lords, they were, my lords, I'm ready, that amount has to be repaid, my lords. Since I was unable to complete the higher studies, I returned back and I joined. But as on today, I'm eligible for the post of professor, but they are not even promoted me as the associate professor.
In view of the affidavit in reply, in view of the compliance affidavit, prima facie, the order is complied with. Our learned advocate, Mr. So and so for the complainant wants time to seek instructions put upon 12th of December at 2:30.
There's a subsequent development, my lords, where the complainant accepted that he will pay a rest of amount, my lords.
My lords, I agree, my lords.
My apologies,
My lords,
my lords.
what has happened,
There is
my
no
lords, in this
translation
matter?
copy.
My lords, I was an, my lords, what has happened, my lords, in 2000,
I know, madam, about this.
My apologies, my lords, that
So let it come on.
I'll file a memo, my lords.
Come on 12th, he will.
please, my lords, please, much obliged. So I'll look into it and I'll get instructions and I'll make submissions.
So Srinivas V, 34.
We have the BBMP, my lords. May I seek for a short accommodation to file my response, my lords. I seek a short accommodation to file my response.
After.
Yes, my lords.
17 January, as requested by learned advocate, Mr.
SH Prashant, my lords.
Prashant.
35, 36 are urgent. Seal number 37. Mr. Virupakshaya PH. 37. Virupakshaya
But-
PH. 37.
Give some date.
Number 38. Sumati.
My lord, kindly may refer page 20 of the, my petition, my lord. The order was very clear of the single bench to consider must consider the application for e-Khata irrespective of endorsement.
We issued an endorsement, my lord, after disposal of the writ petition. My lord, the direction to consider their request. My lord, we have issued, my lord, 4 notices, my lord, 4 times. They have remained absent.
No, my
My
lord.
lord, there afterwards, my lord, on merits, apart from that, my lord, on
They
merits.
submit my.
When you are going to appear.
I've already submitted the documents, my lord. I got the acknowledgement.
When you-
They themselves have given the acknowledgement, my lord. They themselves have given the acknowledgement. And my lord, on the last date of hearing, they were asked to produce the translated copy of the endorsement. Instead, they have added additional documents. How can that be considered, my lord, before this honorable court, when all this
Sir,
was considered before the single bench? The single bench adjudicated after considering all the documents which they have produced before this honorable court. Same set of documents they have produced, and they're introducing new documents, my lord.
The grievance of the complainant petitioner in the writ petition was about issuance of e-khata, which was being pursued by the petitioner since number of years. Learned single judge directed the respondent to consider the request of the petitioner expeditiously within 4 weeks. It is in respect of paragraph, the above direction that the contempt is alleged. When the petition comes up, paragraph for consideration today, it was stated by learned advocate Mr. It was sought to be submitted by learned advocate Mr.
Nagarajappa, my lord.
So and so that the petitioner did not submit the documents.
Yes.
However, on the other hand, the petitioner, learned advocate petitioner, Ms. So and so stated that the petitioner has already submitted the requisite documents and that the acknowledgement is also given by the authority. Be as it may, full stop. The petitioner is ready to submit the documents again.
Yes, my lord, I will submit
It shall
again.
be done within 1 week, full stop. The directions of learned single judge shall be complied with by the competent authority within 10 days thereafter. Full stop. Failing with the
2 weeks,
respondent shall expose to aggravated form of contempt, disposed of accordingly.
2 weeks, my lord, make it 2 weeks.
Next.
Number 39, to Venugopal MS.
For complainant.
Petition is disposed of.
Complaints is filed, my lord.
They have complied.
Complied with.
Complaints affidavit is filed.
Learned advocate for the petitioner as well as learned additional government advocate stated that the order under contempt is complied with, nothing survives in the proceedings. Petition is disposed of accordingly.
Right.
Just next.
To number 40, Rajesh Kumar.
My lords, for the complainant, my lords, I filed an IA, my lords, seeking for an amendment of the cause title. I filed an IA seeking for amendment of the cause title, my lords. By mistake, the name has been shown wrongly, my lords.
Learned advocate wants to amend the cause title, put up on 3rd February. Yes, next.
My lords, I have filed the application.
What is pen? Which? Amendment application.
I have filed the application already, my lord.
Application for amendment seeking amendment to the cause title, the name of the respondent.
Respondent number 1.
Is allowed.
Accused number
The
1.
amendment shall be carried out within
My
1
lords, the
week.
day's time.
Within 1 week. The contempt petition may be posted thereafter. The order in IA.
This is number 41. To the BV Nidhishri.
Hearing for the petitioner in this matter. This matter pertains to the daily wages workers of the Dharwad and High Court bench. Last occasion, your lordship had directed the state to seek some clarification.
They are court employees. They are court employees. Employees of. Correct. Will not entertain the PIL. You can approach the competent if you.
I'll seek instructions. My senior is unable to come today. Week later, the matter will be posted. We'll advance arguments on that. regard.
This is 2014 petition.
I understand, your lordship. Today, there's some inconvenience. Maybe posted next week.
12th of December at 2:30. This is the order we are proposing to pass and dispose of the petition on that.
Yeah.
Yes, next.
This is number 42, The GS Venkat Subra.
By an order dated 12/3/2024, there was a direction to the jurisdictional Tahsildar to submit, my lord, a report in a sealed cover. By an order dated 12/3/24, there's a direction to the jurisdictional Tahsildar to, my lord, submit report with regard to, my lord, the situation of, my lord, the educational institution from the road and the CL7 liquor shop that is in existence. That has to be placed before the court, my lord, by.
I am appearing for respondents 6 and 8, my lord.
My lord, the report of the Tahsildar is placed in a sealed cover before my lord. Inform ಮಾಡಿದ್ರು series
So they are opening some liquor shop.
Yes, my lord, and the distance was, my lord, was disputed.
Distance from the school was how much?
Yes, so my lords had directed the Tahsildar to measure the distance and to then submit a report. I'm informed that the Tahsildar has inspected, my lord, and he has submitted a report in a sealed cover before my lord.
What is the minimum distance and permission?
My lord, 100 meters, then it was reduced to, my lord, could I just see the report, my lord? I don't have a copy of the report to assist, my lord.
There is no report.
My lord, I was informed that, my lord, the report has been submitted. My lord may have this next week, my lord, I'll
13th.
inform my lord. Yes.
Nothing. It must be a 13.
Yes, ma'am.
13th, I'm not there. Any other day?
Tell your date.
16th or 17th.
16.
Right. The interim order may stand.
Tehsildar Madhu Giri Taluka not submitted any report. So
I'm sorry, my lord, I was instructed that the report has been submitted.
find out what is.
I apologize, my lord, but that's the instructions I got.
On 13 we'll see what. 13 at 2:30.
Even
16.
17th, you last may kindly have it in 17th, my lord. 66 this is difficult for me to attend the court on that day. It might have it on 17th, my lord.
18th.
Yes, my lord.
So, great. Interim order may kindly be extended until,
Interim order is there.
Please.
my
Interim
lord,
order
it
is
was
extended.
granted on, in
What
May
interim order?
2023.
Not to, my lord, the license was recommended, not to precipitate further action. My lord.
My lord,
Send
the
out
writ
to-
petition itself becomes infractious
Send
because
out
we
to
had
18th to
issued
be
an
listed.
endorsement to their representation.
Send out to 18 to be listed at 2:30. Interim order already granted, shall continue to operate. Till
Right.
the next. Continue to operate full stop.
Right.
Number 43, KS Bhimaya.
Paper B. Petitioner, somebody wanted time?
My lord, I pray for some time in this matter, my lord.
No, let us see what is it.
My lord, permission,
That
Paradina lands.
Paradina land.
Yes.
Lord, my draft is ready. I need some more time.
At the request of learned additional government, Ms. Nilofer Akbar, stand over to 7th January, 21st January.
Obligation.
Watch.
Number 44. Master RK GMM Mas Swamiji party in person.
Serial number 44, I appear for the respondent, my lords. I'm requesting for a short accommodation by this honorable court. The arguing senior counsel is on his legs in another court, my lords. I'm praying for an accommodation.
My lords, I am ready, man. I am
Ready, ready for adjournment.
No, man. I am ready. Please, my lord. My lord,
You
my
should be
prayer,
ready for adjournment when the council is seeking.
I have to argue at first, my lord. Then they can argue. I have to argue at first. Please, my lord. My lord, my prayer in the appeal, my lord, to set aside the impugned order dated 28/6/24, passed in writ petition, so and so, my lord, and to grant reliefs prayed at B to E at prayer column of the writ petition, my lord. My lord, or alternatively, my lord, kindly delete or expand the adverse you made as poor in the para 1 of internal page number 4 of original impugned original resolution dated 22nd October 19, my lord, at annexure J, my lord. It is made in the process of promotion and in the process of decision making, my lord. And please, my lord.
One minute. 1 minute. Number 45.
My lord.
To Praveen HP from the admin.
Okay, please.
This is a matter regarding DMRCL's acquisition.
So we are disposing of the contempt.
The perusal of the directions, pleadings, affidavit, counter affidavit, and reversed affidavits indicate that the directions issued in the order under contempt are substantially complied with. The complainant's contention regarding the dispute over the extent of the land utilized involves a question of fact which cannot be adjudicated within the scope of contempt jurisdiction. Having regard to the above aspects, as noted above, this contempt petition would not survive for consideration, accordingly disposed of. Complainant may pursue his grievance in accordance with law. No opinion is expressed on merits.
Is 46 or 40?
Hearing for the accused number 3, my lord, town panchayat. 46.
Pardon? Next matter.
Yes, my lord.
You take permission of party in person. All right, all out next. Yes, what is it?
46, my lord. I am for the accused number 3, town panchayat, my lord. I pray for short accommodation to file my reply in my.
Taking time. Okay.
Yes, my lord.
As my lordship is.
I have implemented later, my lord.
When do you want?
Any date, my lord.
Tell the date. January? Somewhere in January?
Yes, ma'am.
6th of January, if it's possible.
7th
First-
January.
first-
7th January.
6th or 7th.
7th.
7th. Much obliged, my lordship.
Yes. Yes, what is?
44.
My lords, I have also sought alternative prayer, my lord, to delete or expand the adverse you made as poor, my lord. It is made in the para 1 of internal page number 4 of impugned original resolution dated 22nd October 19.
Your appellant has come.
At annexure J, my lord.
When shall we keep?
They never appear, they have not appeared from past 1 year. They have made a wrong.
You convey that the matter was called out and the court was awaiting you. At your, you have to convey to your counterpart. Do it. Monday?
At the earliest of the list.
But you inform the.
I deeply obliged for my comments, sir.
Forget it. We have forgotten everything. Don't remind.
Please, my lord.
Number 44, 40.
I sought alternative relief, my lord. Delete or expand the adverse view made as poor in para 1 of internal page number 4 of impugned original resolution dated 22nd October 19 at annexure J, my lord. In the process of promotion and in the decision-making process, it is made, my lord, on the quality of 5 judgments of preceding 5 years, my lord, and it may be ordered for reconsideration of supreme scale promotion to the appellant as per the existing judicial order dated 19/8/21 of Honorable Supreme Court of India, granted in favor of appellant, my lord, in pursuance of favorable first resolution of Honorable AC1 and no that of favorable recent 6th resolution deferring the matter, that is consideration of supreme scale promotion, my lord. Yes, per law, my lord. My lord, I have 2 grievances, my lord. I have agreed by introduction of new practice of assessment of merit by assessing the 5 judgments of preceding 5 years decided by the district judges, my lord. And it's surprise and retrospective application, my lord. My lord, my second grievance, my lord, adverse view made as poor on the said judgments, my lord, and consequential denial of supreme scale, my lord. My lord, the impugned resolution is, my lord, impugned resolution is that, my lord, annexure J, my lord, page number 167, my lord. Page number 167, my lord. My lord, the committee considered the case of Mahaswamiji, presently working as so-and-so. The committee also considered his grievance made by him in his representation regarding failure to grant him functional promotion at district at supreme scale promotion. Page number 167, my lord. My lord, Administrative Committee 1 in its meeting held on February 21, 19, resolved to grant functional promotion to the judicial officer as district judge selection grade on and from February 25th, 2013, my lord. That is the date of eligibility, and his seniority was restored accordingly, my lord. This resolution was approved by the full court on April 17, 19, my lord. My lord, while selection grade was granted to me, ACRs are only considered for assessment of merit, my lord. Even when I was granted selection grade promotion, my lord, 2 district judges were also granted supreme scale promotion. They are 1.5 years junior, my lord, and they were also granted supreme scale promotion on the basis of ACRs only, my lord. My lord, further, my lord, Administrative Committee 1 in its meeting held on June 11, 19, my lord, resolved to direct the registry to place all the records, including judgments and ACRs of judicial officer for considering his case for grant of functional promotion as district judge supreme scale, my lord. It was resolved that in a government order dated April 22, 2016 and recommendation of First National Judicial Pay Commission, FNJPC, accepted by Apex Court, cases of district judges for conferring selection grade and supreme scale will have to be considered on the basis of made cum seniority, manner. And as such, subject was resolved to be placed in the next meeting of Administrative Committee 1 for consideration. Administrative Committee 1 in its meeting held on July 18, 2019 had perused the GO dated April 22, 2006 and recommendations of FNJPC accepted by Apex Court in the matter of All India Judges Association and others versus Union of India and others reported in 2002 Karnataka Law Journal 26 SC, whereunder it has been observed that subject to various modifications in this judgment, all other recommendations of SETI Commission are accepted, and as such, result that for conferring selection grade and supertum scale, assessment will be on Medcom seniority. In the light of above order, Administrative Committee 1 in its meeting held on July 18, 2019, directed the registry to place copies of judgments of the said judicial officer, his ACRs and other service records for consideration of committee. In the meeting of Administrative Committee 1 held on August 6, 19, it was noted that page number 169, my lord. In the meeting of Administrative Committee 1 held on August 6, 2019, it was noted that only 4 judgments had been called for. It was resolved that one more judgment should be called for, and thereafter subject be placed before the committee for consideration. It was further resolved to get the first judgment of the year 2017 in the criminal case delivered by the said judicial officer by downloading the same from National Judicial Data Grid. In the meeting held on September 5, 2019, AC1 resolved to postpone the consideration of the subject, as some of the members had expressed the view that time was needed to go through the judgments. Next, my lord, it is also mentioned, my lord, the committee was of the view that as Medcom seniority is the criteria, selection grade and supertum scale promotions cannot be granted only upon considering the remarks made in ACRs, vigilance statement, and disposal statement of eligible officers. My lord, the remarks in the ACRs, vigilance statement, and disposal statements are all good and satisfactory, my lord. And it is further mentioned, my lord, for considering the merits, appraisal of judicial performance is also necessary, which can be made only after considering the quality of judgments of the eligible judicial officers. It is mentioned, my lord, the quality of judgments are already available in the ACRs, my lord. For considering the merit, it can be considered, my lord. Further, my lord, it is mentioned, my lord, the committee perused the entire service record of judicial officer and 5 judgments delivered by him. The members of the committee were of the view that the quality of his judgments was poor. It is the adverse view made in the process of promotion and in the process of decision making, my lord. It is sought for expansion, my lord. My lord, it is further mentioned, my lord, after making appraisal of judicial performance of the said judicial officer.
Madam,
9th or 10th, my lord. 9th or 10th, my lord. This month, please, my lord. 9th or 10th,
now no time.
please, my lord. 9th or 10th,
9th or 10th, not possible.
my lord, please.
Please give date after. It can be on 22nd.
My lord, 9th or 10th,
January.
please, my lord. Urgency. Please, my lord. My lord, it is, issue is also covered by the judgment of coordinate bench, my lord.
We'll take it.
Rajshekhar Sajakan
We'll
versus
take
state of Karnataka, my lord. It is already covered, my lord. AC has to be considered for grant of supertum scale. It is clearly held, my lord.
After holidays.
9th or 10th, my lord,
9th or 10th?
of this month, my lord.
No, month will be decided.
Please, my lord, please, my lord.
9th or 10th of January it can be.
No, my lord, please, my lord.
Not possible.
Please, my lord.
9th January is possible, 10th January is
Your
possible.
lordships kindly.
My lord, please, my lord, please, my lord. It may be 16th, my lord. 16th of this month, my lord.
It
Please,
will
my
not-
lord.
Kindly.
Go-
Please, my lord. Please give me half an hour, my lord. Please give me half an hour, my lord. Please, my lord.
It will not. be
Please give me half an hour.
No, we know.
I will read the decisions, my lord.
We know.
I will convince the position of law, my lord.
We know your half an hour.
Please, my lord, please.
Lordships kindly.
Not possible.
Please, my lord.
Take a
16th of December. Please, my lord, please, my lord.
That
Please, my lord.
16th. Take
16th, my
chance.
lord.
No guarantee that it will be proceeded.
Please, my lord, please.
Take chance, yes.
Your lordships kindly. Serial number 55, your lordships heard on last occasion. Just a
55.
writ, 55, serial number 55. Just a writ of nature of mandamus because there was some misconception in the government advocate order copy. So I've rectified it. It's just only a mandamus to be considered. My application is pending before the government, your lordships. So may I request,
So what
one-
was to be rectified?
I've given the copy. Annexure A was, translation copy was missing. So I've reproduced that and I've given the copy, your lordships. So it's only written in the nature of mandamus considering my application to be considered. It's a private patta land, grant land. There's a report saying it's a safer zone declared. It's not a forest land. So in view of that,
We remember, 9th December at 2:30.
much obliged.
In item 107, your lordship, if I can be accommodated.
As on the date I filed the writ petition, the department was not the scheduled trial department. After the disposal, when I filed the contempt, now it has been as a tribal welfare department. That is a submission, my lords, in a contempt. Notice has to go.
No.
The department has been changed, my lords. That's all.
Which,
The name of the-
which matter?
108.
What is to be done?
Notice.
No, without seeing, we will not issue notice for this.
My lords,
Without seeing the matter, we will not issue notice.
Petition is that, my lords, while disposing the writ petition, the department was Karnataka Scheduled Tribe Development Corporation. Now it has been
Notify on 13th.
My lord, serial number 82,
My lord.
my lord. IO may be extended, interim order. Serial number 82, my lord. Interim order may be extended.
Everywhere it will be, wherever it is there.